किन लोग का?
सारा काम है। कोई 7, 8, 9 कैलकुलस का हिस्सा है, दैट इज द स्टार्ट ऑफ योर 12th स्टैंडर्ड। मैं पहले ही बता के रख रहा हूँ, अगर आप एब्सेंट रह रहे हो चॉइस ऑफ एस नहीं है। मैं अगर करना ही नहीं है तो फिर वो होगा नहीं। मैथ्स वन बहुत अलग सीन है। एस वाई जे सी में कभी बच्चे मिले तो पूछ लेना। हो गया, सिखा दिया फंक्शन। टू मिस द फंक्शन, वेरी गुड चैप्टर। बहुत इजी था क्योंकि तुमको कम दिया है ना, तुम्हें बहुत कम दिया इसलिए आपको इजी लगा। वो आया नहीं, ये नहीं रहे वो जो एक है ना, वो गणेशा की तरह दिखता है, छोटा ही है ऐसा, छोटा बाल है और बेटा रहे। हाँ, कोई प्रीत है, मीत मीत है, मुझे नहीं मालूम। उस साले पीएनसी चालू हो गया, परमिशन कॉम्बिनेशन खत्म हो गया कि चालू हो गया? बढ़िया चैप्टर है, मजे वाली है, पूरी दुनिया गिन सकते हो उसमें। लग जाएगी। हाँ, सेल्फ स्टडी में नहीं जाते हो चैप्टर्स। चलो, एक काम करो, चैप्टर 5 स्टार्ट करना था मुझे, और कर भी दे सकता हूँ, लेकिन 30।
चलो शुरू करें। यस, सो वी आर गोइंग टू स्टार्ट विथ directors chapter today. Yes, again one of the very important chapters. Chalo, now in this chapter we can revise the entire chapter. Okay, I just want you to do two things from my notes. Rest everything we will be doing it from module. Okay, why from this? Because इसके अंदर जो दिया है, जैसे two topics, one is DIN number, which you have done in your setting up of business also, and the company law lecture also, and another is independent director. Now independent director, if you know our notes, in that we have done examples point wise, so that would be more better, right? So two things from the class notes, rest everything we'll be doing it from module. Okay, so let's start. Now see friends, directors. Now again here you can see the definition of board of directors. So you know individually a person is called as a director, and all the director collectively known as board of directors. Very simple, right? You know company is an artificial person, Therefore, company needs a natural person to act on its behalf. So, who is that natural person who acts on behalf of company? That is a director, right? Here you can see company is a separate legal entity. It is an artificial person, right? But it is not a natural person. It cannot act on its own. Therefore, it needs a human intervention. It needs a human agency. Okay. So, who is that person who acts on behalf of company? Answer is director. Right. And then individually he is called as a director and collectively known as board of directors. Fine. Now, yes. So, first topic itself is DIN. Yes, as I told you, DIN and independent director, not even independent, only the eligibility part, you can do it from our notes. And yes, for DIN, we can go with some basic, you know what is DIN? Who needs a DIN? Every person, any person who intends to become a director of company needs to have a DIN. DIN is 8-digit number which you can get by making application on MCA portal, correct? So that is every director must have a DIN, right? And then we did for procedure for application of DIN, cancellation of DIN, surrender of DIN, right? Changes in the details of DIN. So all these things you can see here. Application for DIN must be made in form DIR 3, correct? So all these things, this is everything related to, so you see this about the changes. Yes, above it was about application, cancellation and surrender of DIN, right? Then KYC of DIN, and then here we start with the chapter. Yes, so the first topic is types of director. The first one is first director of company, that is given in section 152. Very easy topic, right? Who will be the first director of company? So obviously the person whose name is mentioned in the articles of association shall be the first director of company. Person whose name is mentioned in AOA as a first director shall be the first director. Okay. But what if there is no provision in AOA? No name is mentioned in AOA, then who will be the first director? In such case, answer is subscriber to MOA, who is an individual having a DIN, shall be deemed to be the first director of the company. Okay, very simple. So generally it is the person whose name is mentioned in AOA as first director. If no name is mentioned in AOA, then subscribers to MOA. I hope you, who is subscribers to MOA? Who is subscriber to MOA? Yes. Do you know who is a subscriber? Subscriber is another word for member. Subscriber is another word for member of company, right? But we are talking about subscriber to MOA. Subscriber to MOA means first member of company. Like in private company, you know, 2 or more members are required minimum. Public companies, 7 or more members are required minimum, right? So these 2 or more, 7 or more, these are the members who had incorporated the company, who became the first member of company. You know, this first member's name is mentioned in MOA. Name, number of shares held by them, and also their signature. Yes or no? Yes. So friends, this thing is a part of MOA. So tell me one thing, companies write, companies note down the names of all the members in MOA? No. Companies note down only the name of first members of company. Yes or no? In MOA, not in ROM, in MOA. Understood? So those first members are also the members. Today if we buy shares of Reliance Industries Limited, even we are members today, shareholders today, right? So we are also the member, they are also the member. But who is special, we or they? They, because their name is mentioned in MOA, they are the first members of company. So that is called as subscriber to MOA. So if no name is mentioned in AOA, in such case, subscriber to MOA shall be the first director of the company. Easy? Yes? Yes. Until the directors are duly appointed in the general meeting. So this was about the first director. But what if I ask you the same, okay, this rule about the first director, just now whatever we have discussed, the same rules are applicable for all companies, that is public as well as private. For all companies, same rules are applicable, okay? Secondly, what if I ask you same question in case of one-person company? In one-person company, who shall be the first director? Again, the person whose name is mentioned in AOA as the first director. But what if the name is not mentioned? So if no name is mentioned, in such case, the whole and sole member of OPC, you know, in one person company there is only one member. So the sole member of one person company shall be deemed to be the director of first director of the OPC. Okay, so yes, the individual member shall be deemed to be the first director, right? Easy. So this was about your first director of company, very simple. Right? Please remember this sections 152 talks about first director. Okay, yes, then let's go to the next topic, that is resident director. It is given in section 149 subsection 3. Okay, what is resident director? So the topic says that out of total number of directors in a company, out of total number of directors, at least one director must be resident director. At least one director must be resident director. Means what? Means out of the total number of directors, at least one director must be resident of India. Okay, yes, at least one director must be resident of India. Okay, what is this resident of India? Resident of India means person who has stayed in India for a period of not less than 182 days or more during the preceding financial year. It is not calendar year, it is financial year. Very simple. How many days? 182 days or more in the preceding financial year. So out of the total number of directors in a company, at least one director must be such who has stayed in India for 182 days or more in the previous financial year. Easy? Yes. This was one point, okay? This is one point. It is still here. Okay, and there is one more point in this topic, resident director, that is in case of newly incorporated company. Okay, what if our company is newly incorporated? Let's say our company was incorporated in October. Okay, so you know the definition of financial year. So what will be first financial year for our company? The date of incorporation, that is from October to 31st of March. Now what if we go in the next financial year? We will enter, our company will enter in the next financial year after 31st of March. That will be again from April to March. So in the next year, when we saw out of the total number of directors, at least one director must be resident of India. At least one director must stay in India for 182 days or more in the preceding financial year, right? But what is preceding financial year? Financial year matlab 365 days. 365 days generally. Right? But if you see the financial year of our company, when our company has entered into the next financial year, we will see previous financial year. So our previous financial year was from October to March. Are you getting the point? So that way it is. So in that case, how to calculate? Because in that case now, out of total number of directors, at least one director has to stay in India for 182 days or more. But here our previous financial year was not of 365 days. It was for less than 365 days. So in that case, how can a director stay in India for 182 days? So in case of newly incorporated company, you have to satisfy this requirement proportionately. You understood? Means if a person has to stay in India for 180 days or more out of 365 days. So if your financial year is for less than 365 days, so accordingly you have to, by doing the cross multiplication, you will get the answer. So that is proportionately. Okay, so I hope this is clear. Very simple. Resident director. So 2 points in this. Okay, yes. Next topic is woman director. What is woman director? So this is again part of section 149. You know, earlier in Companies Act 1956, there was nothing like a woman director. When Companies Act 2013 came, then this new type of director was added in the Companies Act, and that is woman director. So what is the rule? The rule says that out of the total number of directors, at least one director must be woman director. At least one director shall be woman director. That is the rule. Okay. But this rule is applicable for which companies? Is this for all the companies? No. It is applicable only and only for every listed company. You know, for every public listed company, it is compulsory to have at least one director as woman director. What about other companies? So for other companies, firstly it is not other companies, it is other public companies. Means we are talking about public unlisted companies. So for public unlisted companies, you need to appoint at least one director as woman director only if conditions are getting satisfied. What are the conditions? Conditions are if paid up share capital is 100 CR or more, or turnover is 300 CR or more. Only then rules are applicable, otherwise no. Okay, so do we need to check the conditions in case of public listed company? No. For public listed company, no conditions, it is applicable, compulsory. Okay, but for other public companies, that is public unlisted companies, you need to check the conditions. Easy? Any doubt in this? Okay, fine. So this was the basic applicability of woman director provision. Now we are going to SEBI LODR. Yes, means we are going to talk about listed companies, right? So here the rule is about top 1000 listed companies. Top 1000 listed companies with effect from 1st of April 2020. Top 1000 listed companies have to see it is listed company. Means anyways they have to appoint woman director. But top 1000 listed companies have to appoint at least one woman independent director. Woman independent director, not only director but woman independent director. Okay, you know independent director, unbiased one, right? Yes, and when we talk about independent director, he is a person who satisfies the requirement of 149 subsection 6, that is the eligibility for becoming an independent director. So if you are a top 1000 listed companies, you need to appoint such a woman director who satisfies the eligibility criteria of independent director also. Okay, so that is the requirement for top 1000 listed companies. Initially this requirement was applicable for top 500 listed companies also. That is with effect from 1st of April 2019. But right now we are in 2025. So now top 500 listed companies will not make sense. Because when we talk about top 1000 listed companies, it is already including top 500 listed companies. Okay, yes, now you know this very well. The top listed companies are determined on the basis of its market capitalization. Okay, very simple. Yes, this was about your woman director. But I hope you know we did something more also in class. I spoke about vacancy, I spoke about what will happen for existing companies. Means companies which are in existence, companies which are in existence before commencement of the act. Correct? Yeah, but that is not given here. So it's okay, we will go with the module. But yes, what about vacancy? If there is vacancy in the office of woman director, come on, vacancy shall be filled up within how much time? If there is vacancy in the office of woman director, vacancy shall be filled up within 3 months or next board meeting, whichever is later. Correct? So that is the rule for filling up the vacancy of woman director. Yes, next we are moving to small shareholder director. Yes, I hope you know this small shareholder director. Firstly, who is a small shareholder? So small shareholder is a shareholder whose holding does not exceed 20,000 rupees as per face value of shares. Whose holding does not exceed 20,000 rupees as per face value of shares. That is nominal value of shares. That shareholder is called as small shareholder. But in this topic, we are not going to talk about small shareholder. We are going to talk about small shareholder director. Okay, yes. So small shareholder director means section number 151. Okay, so what is the point? Yes, so here we start with it. Firstly, why do you need a small shareholder director? Yes, I told you, like, always company and law tries to protect the interest of investors. So to protect the interest of small investors, there is a person to regain the trust of investors. There is a person appointed called as a small shareholder director. So what do you think? In which companies general public can invest money? Public listed company. Therefore, this type of director is required to be appointed in public listed company only. And that is also not compulsory. This is not compulsory. You know, in public listed company may appoint. It is may appoint small shareholder director suo motu basis, or when application is made to listed companies. Okay, come on, once again, who will appoint small shareholder director? Small shareholder director is appointed in listed company, and listed company may appoint small shareholder director suo motu or on application. Okay, come on now, who will make the application? Who can make application to listed company? Small shareholders, or come on, how many small shareholders? That is 1000 small shareholders, or one tenth of the total number of small shareholders, whichever is less. Okay, so these many small shareholders can make an application to the company, and then company will appoint small shareholder director. Is this clear to everybody? Can you see this? Small shareholder director may be voluntarily be appointed by listed company. Okay, listed company may on its own or on application. Is this clear to everybody? Any doubt in this? So this was about appointment of small shareholder director. Next, if any of the person, any of the shareholder, any of the person wants to become a director of company, how can he become a director of company? Can you become a director in a company? Yes, what you need to do? Do you remember section 160? That is about appointment of director. Yes, come on, fine. So if any one of the small shareholder wants to become small shareholder director, so what he can do? He can make an application to the company when? At least 14 days before the date of AGM. You understood this much? So any person, any small shareholder intending to become a small shareholder director for the post of small shareholder director, he can send a signed notice to the company at least 14 days before the date of AGM. Now, in that notice, he is going to explain his candidature. He is going to explain his candidature, his intention to become small shareholder director. Are you getting the point, everyone? Yes. Now, along with that, you have done section 160. If you remember, you need to give deposit money and all those things, right? But here we are not discussing that entire process. That we will be discussing in section 160. But here same thing is applicable. So any small shareholder can make an application to the company at least 14 days before the date of AGM explaining his candidature. Now what will company do? Company will send your details to its members. Now in AGM, members will vote. If you get the requisite vote, you will be appointed, correct? Or you will not be appointed, depends on the voting, right? So this notice include all the details as I told you, correct? Yes. Now that person who is going to send this kind of notice to the company explaining his candidature, he will mention his DIN number. He will also mention his details, particulars as I told above. He will also give a declaration that he is not disqualified to become a director of company. He will also give a declaration that he is not disqualified to become a director of company under section 164. Correct? also his consent to act as a director. Everybody understood? So this kind of notice is going to send. Now tell me, this person, small shareholder director, if a person is a, suppose if I am a small shareholder director in a company, can I also act as independent director of that company? Can a person can act as both small shareholder director as well as independent director? So answer is yes, if I satisfy the requirement of 149 subsection 6, that is eligibility criteria of independent director. In that case I can act as both. So you can see here, if he is eligible to be appointed as independent director under section 149 subsection 6. Okay, so such kind of person needs to give a declaration of his independence under section 149 subsection 7. Do you remember this? That he needs to give a declaration that I satisfy all the requirements of 149 subsection 6. Okay, so yes, same person can act as independent director also. Yes, what is next? What will be the tenure of independent director? So his tenure is of independent director 5 years, correct? But here we are talking about small shareholder director. What shall be the tenure of small shareholder director? Firstly, you know there are two kinds of director. Directors who are liable to retire by rotation, directors who are not liable to retire by rotation. So what about small shareholder director? Is he liable to retire by rotation or is not liable to retire by rotation? So he is not liable to retire by rotation, and his tenure is fixed. His tenure is of 3 years. Okay, on expiry of 3 years, can he be reappointed? Can he be reappointed? He is not eligible for reappointment after expiry of his tenure. Are you getting the point? It is. No, there is cooling period. No, once he sees the office, he cannot be appointed as, he cannot hold any position in the company for a period of 3 years. Okay, the point is already given in the notes as well. Okay, so you are clear with this? So tenure is 3 years. Now if I talk about eligibility, who can become small shareholder director? Come on, tell me, can a small shareholder himself can be appointed as small shareholder director? Yes, small shareholder can become small shareholder director. Can a person who is not holding any shares in the company can be appointed as small shareholder director? Yes. So small shareholder, person who is not holding any shares in the company can also be appointed as small shareholder director. But a person whose holding exceeds 20,000 means he is a big shareholder. Can he be appointed as small shareholder director? Answer is no. However, in law there is no such term called as big shareholder. I hope you know that. Correct? But yeah, we are considering it the person whose holding exceeds 20,000, right? Yes. So I hope this is clear. Here you can see eligibility criteria. Who can become? Or you can just write it down over there. Okay, already you have this in your notes. So who can be appointed? Person who himself is a small shareholder, or he is not a shareholder only. Okay, but person whose holding exceeds 20,000 cannot become small shareholder director. Fine. Then this small shareholder director, again, he have to vacate his office. Disqualifications for small shareholder director shall be same as for other directors. That is section 164. Okay. Now this small shareholder director have to vacate his office, okay, in the following circumstances. When he is liable to vacate his office, first point is when he ceases to be a small shareholder. Yes, I hope you know that. If he ceases to be a small shareholder, they are saying, they are not saying he ceases to be a shareholder. He ceases to be a small shareholder, means now he is a big shareholder. I told you, person whose holding is exceeding 20,000 cannot be appointed as small shareholder director, right? So if he ceases to be a small shareholder, then if he incurs any disqualification under 164 which talks about disqualification of director, then if a person is liable to vacate his office under section 167. I hope you know what is 167. Vacation of office of director. Okay, so under that, if he is liable to vacate his office, again he will have to vacate his office here. Next, as I told you, small shareholder director can also be appointed as independent director, right? Means a person is appointed as both small shareholder director also and independent director also, because he was satisfying the requirement of both. So can I say a resolution was passed, and resolution says that he will be appointed as both, correct? So now he will have to satisfy the requirement of both independent director eligibility also and small shareholder director eligibility also. So if this person, suppose if this person ceases to meet the criteria of independence, that is 149 subsection 6, that is eligibility criteria of independent director, if he ceases to satisfy the eligibility criteria of independence, then he will have to vacate his office. Understood? Now you will say that, sir, but can he continue as small shareholder director? No, because he was appointed as both by passing a resolution. Therefore, he will have to satisfy the requirement of both. Okay? Yes. Now, next is number of small shareholder directorship. Now you tell me, generally a person can hold directorship in how many companies? Generally, a person can hold directorship in how many companies? Come on, tell me section number first. Section number 165. Okay, and a person can hold directorship in how many companies maximum? 20 companies. So can you become small shareholder director in 20 companies at the same time? Answer is no. You can become small shareholder directorship in maximum 2 companies, not more than 2 companies. Okay, not hold the office in more than 2 companies. Also, there is a condition for this. That is, the second company must not be in competition with the business of first company. You understood? If I am already a small shareholder director in one company, now I want to become small shareholder director of another company. So I can become small shareholder director of another company, the second company, if the business of second company is not in competition with the business of first company. Only then it is allowed. Otherwise, 2 is also not allowed. Okay, yes. Now, yes, as I told you, once you ceases the office, once you vacate your office as small shareholder director, now such person cannot be appointed or associated in any other capacity with the company, either directly or indirectly, for a period of 3 years from the date of cessation as small shareholder director. Means now you cannot hold any position in the company, okay, any position in the company for a period of 3 years. Is this clear to everybody? Very easy point. Yes? Yes. Now next is, here's this notes also you can see. Small shareholder director may be removed by passing OR in general meeting. Yes, that is in accordance with the provision of section 169 of the Act. Do you remember this? What is 169? Removal of director. And we have done that. Director can be removed by passing ordinary resolution. The same thing we are saying here. He can be removed by passing ordinary resolution. Okay? I hope this is clear. Now tell me one thing. If we are saying that by passing ordinary resolution and we are removing small shareholder director, tell me which shareholders can come and vote? All shareholders can vote or only small shareholders can vote? When we say passing OR, means OR in the general meeting. In general meeting, every member can attend the meeting. Right? So make sure that, see, at the time of voting on such resolution, every equity shareholder have right to vote, irrespective of the fact whether he is a small shareholder or not. Means every. Okay, I hope this is clear, everyone. YouTube, online students, clear? Everyone, are you listening? Yes. And when we talk about small shareholder director, obviously he is also a director. He is also a part of board. He is also going to come in the board meeting. Yes or no? Therefore, he shall be included while counting total number of directors. Okay, very simple. Yes, so this was your next type of director. Next we are coming to independent director. That is again 149. So obviously we are going to do few points here, but I told you the applicability, the eligibility part, you need to do it from our notes. Okay, or you can follow your faculty notes also for eligibility. So please concentrate. Come on, you know who is an independent director? Independent director means a director who is biased or unbiased. Unbiased, who is not going to take the favor of company, who is not going to take the favor of members also. He is neutral, right? So right is right, wrong is wrong. So such type of unbiased people in the board is good or bad for the company? That is very good, correct? Because all the decisions will be taken in neutral manner, correct? So what do you think, which companies will need such type of director most? Listed companies. So that's what the point says. Every listed company, one third of the total number of director shall be independent director. Every public listed company compulsorily needs to appoint at least one third of total number of director as independent director. Clear everyone? Okay, what about other companies? So it is not other companies, it is other public companies. So it is public unlisted companies. So here they need to appoint at least two directors as independent director, but only if conditions are getting satisfied. What are the conditions? You remember the conditions for woman director? 100 and 300. Paid up share capital or turnover. So here it is 10, 100 and 50. That is, public unlisted company is need to appoint independent director if the paid up share capital is 10 CR or more, or turnover is 100 CR or more, or their borrowings. Their borrowings is exceeding 50 crores. What? Borrowing is exceeding 50 crores. Yes, that is exceeding 50 crores. Okay. Now tell me, this is the applicability. So tell me, do private companies are required to appoint independent director? No. That is only for public listed and public unlisted if conditions are getting satisfied. Okay. Now tell me, once we talk about this independent director, when will a person act independent? When will a person as a director act unbiased in the board? Obviously, when he is not having any interest in the company. When he or his relative is not having any directly or indirectly connection with the company. So, am I saying that he cannot have any shares in the company? He cannot hold any shares in the company. He should not have any type of connection in the company. It is not that. There is eligibility criteria for becoming an independent director, which is given in section 149 subsection 6. Right, which I told you that you need to do it that from the notes, because we have done examples after every point. Correct? So this was about applicability. Now there are few companies which are not required to appoint independent director. Which companies? Unlisted public companies. Listen to me. In the previous slide we saw public unlisted companies are required to appoint independent director if conditions are getting satisfied. But here I am saying that following class of unlisted public companies are not required to appoint independent director. Okay, following class of unlisted public company. So which are those companies which are not required to appoint independent director even if the conditions are getting satisfied? And that is joint venture company, wholly owned subsidiary company, and dormant company. Correct? So you already know about this. Yes. Then audit committee and other committees. There are different types of committees of board. So when you talk about the different types of committees, section 177, 178, do you remember? 135. So in all the different types of committees, when we talk about composition of those committees, means who shall be part of that committee. So in all those committees, in majority of the committees consist of independent director also. So independent director, can you see this, shall also be appointed in different types of committees due to the composition of committees. Okay, that you will study in your types of committees, your chapter board composition. Okay, yes. What if there is vacancy in the office of independent director? If there is vacancy in the office of independent director, you need to fill up the vacancy just like woman director. That is within 3 months or next board meeting, whichever is later. Easy? Everyone clear? Yes. And once the rules are applicable on your company, means once your company falls into this eligibility criteria that you need to appoint independent director. So you have appointed. So once you have appointed independent director, and what if next year your company is not having that much paid up share capital or turnover or borrowing next year. So when you see that preceding financial year is not satisfying the condition now. In the previous year when we checked, applicability was there, therefore we have appointed independent director. Next year now company is not getting covered under the applicability provision. So now what to do? The independent directors which we have appointed, we will remove all of them? No. Because once the rules are applicable on your company, you need to comply with all the requirements for at least 3 years. Okay, then here you can see the definition of independent director which is given in section 2, clause 47. Who is an independent director? So independent director means a director who satisfies the eligibility criteria. So where is the eligibility criteria given? 149 subsection 6. So yes, so here you can see all these points are talking about eligibility criteria. Yes, which I told you that you can do that from your notes. This is eligibility criteria completely. That is subsection 6. Now subsection 7. You know, every independent director have to give a declaration of his independence. Every independent director shall give declaration of his independence. Means he will give a declaration that he satisfies all the requirement of 149 subsection 6. This kind of declaration he will give, and when he will give? He will give this kind of declaration when he attends the first board meeting as a director. Means after joining, in his first board meeting he will give this declaration, and also in first board meeting in every financial year he will give this kind of declaration of his independence. Come on, when will he give this declaration? In the first board meeting after joining, then first board meeting in every financial year. Okay, and also whenever there is any change in the circumstances which affects his status as independent director, so he will have to give declaration in this manner. Okay, so this was your subsection number 7. Then remuneration for independent director. Firstly, you tell me one thing. Independent director is what kind of director? Executive or non-executive? You know there are two types of director. Executive director and non-executive director. Executive director covers only two types of director, that is managing director and whole time director. These two are called as executive director. Other all directors are called as non-executive director. Correct? Yes. So now friends, here as you know, independent director is non-executive director and the remuneration is paid only to the executive director because they are the employees of company. Non-executive director are not employees of the company. Executive director will work just like any other employee, full-time employment, but non-executive director are not the employees, therefore they don't have to come every day. They just come and attend the meetings of company. They just attend the board meeting. So as independent director are employees, they get salary. Non-executive director, executive director are the employees, therefore they get salary. Non-executive director are not employees, therefore they don't get salary. Right? So what about the remuneration as independent director? Are they employees? No. So do they get salary? No. They get only sitting fees. They only get fees to attend the board meetings and committee meetings. But there was an amendment. I told you, as per Companies Amendment Act 2020, now remuneration can be given to other directors also. That means non-executive directors also, which includes independent director. So means now, can company give remuneration to independent directors? Answer is yes. Now company can give to them. Correct? Yes. And independent director also get traveling expenses. That is reimbursement of traveling expenses. They can, yes, they can get any amount in the form of commission as approved by the members. Do they get ESOPs? No, they are not entitled for ESOPs, because ESOPs is for employees. These people are not employees. Correct? Yes. So that is where it is. And then I told you that there was an amendment. Here you can see director may receive remuneration, right, as per schedule number 5. Yes. Sorry. That is given to any director. But the provision, right? It is given only when there is they add on anything to the company. Because that is for directors and other employees. Is this clear to everybody? What is next? Now here, the term of independent director. Excuse me. We are going to revise that chapter. So please wait for it. Don't create confusion for others, because there are chances that these people can also hear your voice. We will go to that chapter, don't worry. Entire chapter will be revising share capital from module. So don't worry. Live in present. Okay, chalo. What is the tenure for independent director? Independent director can be appointed for 5 years by passing ordinary resolution, okay, by shareholders. Once the 5 years tenure is over, can he be reappointed? He can be reappointed for another 5 years by passing SR. He can be appointed by passing OR. He can be reappointed for one more term of 5 years, that is by passing SR. Okay, come on, he has completed his second term also. Now can he be reappointed again? Can he be reappointed again? Yes, no. Can he be reappointed again? Answer is no, because he can enjoy maximum 2 terms of 5 years each. So 5 plus 5, that's it. After that he cannot be reappointed by passing SR also. Is this clear to all? Okay, but you know what? This person can be again appointed in the company as independent director, as non-independent director, only after expiry of cooling period of 3 years. So 5 plus 5, then cooling period of 3 years, then again he can be appointed for 5 years. 5 plus 5. Okay, so this was about the term of independent director. You can read everything, same is given here. 5 years, he can enjoy 5 years. Reappointed for further 5 years by passing special resolution in general meeting. Correct? Hey, tell me one thing. After 2 years, he may be appointed only after expiry of 3 years. That is cooling period of 3 years. Okay? Yes. What if independent director was appointed originally for less than 5 years? For his first term, he was appointed for less than 5 years. Let's say he was appointed for 3 years only. Now 3 years is over. Now he can be reappointed for 7 years? No. So total, if you see, it is 5 plus 5, that is 10 years. That is maximum term. But if you have appointed independent director for less than 5 years, let's say for 3 years, so he can be reappointed for maximum 5 years only. Because independent director cannot enjoy more than 2 terms of 5 years each. 5 years each. Are you getting it? So that is the point, okay? So I hope this is clear to everyone. Here you can see It has been clarified that if he is appointed for less than 5 years, then he can enjoy maximum reappointment of 5 years only. Okay? Yes. Then he is a non-executive director, already I told you, right? Then here you can see a case law. Yes. I told you that he is liable only for the acts done by him or acts which are approved by him. Whatever is done by him, not for others, not for the other director. That was liability point. Then payment of sitting fees and commission. I told you what do they get? Do they get salary? No. They get traveling expenses? Yes. They get sitting fees? Yes. Can you say that sitting fees? Then reimbursement of traveling expenses or any commission income. But after the amendment, now they are eligible for remuneration also. If company wants to pay after the amendment, it is allowed. Then here you can see the role of independent director, right? All the points. Yes. And here, what is this? Separate meeting of independent director. What is separate meeting of independent director, friends? Independent director conduct a separate meeting. Now, is that a board meeting? No, that is not a board meeting, because in board meeting who can attend? All the directors can attend. We are talking about separate meeting of only independent director. Who can attend? Only independent director can attend. Why do they conduct separate kind of meeting? That is to evaluate the performance of other directors. Which directors? Non-independent directors. Correct? They also evaluate the performance of the chairman of company. They also evaluate the performance of company. They also see the compliance is getting satisfied or not. So all these things they do in their separate meeting, which is held at least once in a year. Okay, yes, and now we are moving to the next type as per your module, that is additional director. Okay, that is section 161 subsection 1. In 161 there are total 4 subsections. 161 subsection 1 talks about additional director. 161 subsection 2 alternate director. Subsection 3 nominee director. Subsection 4 casual vacancy. Okay, so we will go with all this. Let's see. What is it? बता क्या है बता ओ क्या कर दिए Chalo. So see, additional director. Okay. See, generally who appoints the director of company? Shareholders. In which meeting? Annual general meeting. Correct. So generally, shareholders appoints the director of company. But you know who is additional director? Who is additional director? Director appointed by board. Okay, that is uniqueness. How to identify additional director? Director appointed by board. You know, board of director may appoint any person as additional director, but only if authorized in AOA. Only if authorized in AOA. If AOA authorizes, then this is possible, otherwise it is not possible. Correct? Now friends, see, generally whenever you see any case study question and when you see that the director is appointed by board, so it is additional director. See, remember one thing, whenever a board is appointing a person as additional director, firstly it is not necessary that there has to be a vacancy. Means there is a vacancy, means if any director dies or leaves the office, vacancies office, he is removed, and then board has appointed a person, that means then he is additional director. That is not necessary. Okay, you just have to keep this in mind. Director appointed by board means additional director. Okay, like for example, if there are total 10 directors in our company and now board has appointed 11th person, 11th director is the company, 11th director of the company. Now tell me, was there any vacancy? No. Person was appointed as 11th director, right? So that director is called as what? Additional director, because he is director appointed by board. Are you getting my point? Is director appointed by board. So that is the identity of this type of director. Now tell me, if board has appointed a person as a director, is that appointment final? No. It has to be appointed by, it has to be appointed by shareholders. Okay, okay, I'll check this. Yes, now I hope screen is visible to everyone. Chalo. Now, who is additional director? Director appointed by board. When board can appoint this type of director? Only if authorized in AOA, right? Vacancy is required? No. Even if there is no vacancy, if board has appointed any person as a director, he is a additional director, right? But appointment of director by board is not final, correct? That director will not enjoy the tenure of 5 years. He will hold the office only and only up to the next AGM. Why? Because in the next AGM, shareholders will ratify his appointment. You know, shareholders may ratify. Ratify means approve. So shareholders may ratify, may not ratify. May approve, may not approve. Are you getting my point? So if shareholders ratified his appointment, he will continue to be the director, because now he is a director appointed by shareholders. But if shareholders does not ratify, he will have to leave the office. Are you getting my point? Let me finish, then I'll give you chance. So understood? So he will hold the office only up to the date of next AGM. Clear everybody? Sure? Now, why we are saying that this person shall hold the office only up to the date of next AGM only? Because I'm asking this question, why they are saying that he will hold the office only up to the date of next AGM? Because there are chances of ratification also. So if shareholders will ratify his appointment, he will continue to be the director. So why we are saying that he's holding office only up to the date of next AGM? Because in AGM, if his appointment is ratified and he continues to be the director now tell me, is he still a director appointed by board? No. Therefore, he is not a additional director anymore. So he is a director as additional director only up to the date of next AGM. So let's revise this point. Come on, who is an additional director? Director appointed by board. One thing. Second, board can appoint any person as additional director only if authorized in AOA. Third point, if a person is appointed as additional director, his appointment is ratified in next AGM. So additional director shall hold the office only up to the date of next AGM. But what if company fails to conduct AGM in that year? If company fails to conduct AGM in that year, you will say AGM conduct is compulsory. Yeah, but if they don't conduct, there is a penalty under section 99 general meetings. So they will pay the penalty. But is AGM conducted? No, AGM is not conducted. So now what about this office? He will hold the office up to what date? So answer is due date of holding AGM. Right? So conclusion is additional director shall hold the office up to the next AGM or due date of holding AGM, whichever is earlier. So that is the point. Okay, so you tell me here generally additional director means director appointed by board, right? So can I say additional director is a director appointed by board means by passing board resolution? Yes or no? Clear everybody? So these are the points for this. You can see here in case of defaulting holding AGM, he shall vacate his office on the due date of holding AGM. Okay, is this clear everyone? And this rule is applicable to both the companies, private company as well as public company. He shall hold the office only up to the date of next AGM or due date of AGM, whichever is earlier, right? All the points are already done. So here there is an illustration. We'll come to that. Yes. Concept forms? It's very simple. See, DIR 12. You know, I told you this in our first lecture of Sanjivani this year. What I told you? That whenever director or KMP is appointed or they are leaving the company, you always have to file DIR 12. Correct? So tell me here, are we appointing additional director? So we need to file DIR 12. So if you understand conceptually, it is not difficult. Correct? Can you see this? Company is required to file DIR 12 for appointment of director. Right? Duly attached the board resolution. Okay, so the board resolution what we have passed to appoint him as additional director, you need to attach that and file DIR 12 with ROC. Easy? 161 subsection 1 everyone, clear? Yes, what is next? Now next we have a subsection 2, that is alternate director. Now what is alternate director? See, alternate director is again a director appointed by board. Additional director was also a director appointed by board. Alternate director is again a director appointed by board. So then what is the difference? There is a difference. There is a difference of circumstances. See, we will talk about alternate director. See, in the word itself it says that it is an alternate. Means this is a substitute director. Means alternate director is a substitute of some other director. You understood? See, for example, what is the specific rule about this? So whenever in our company any of the director remains absent from India, when any of the director in India of our company remains absent from India for a period of not less than 3 months. So if a director is absent from India for a period of not less than 3 months, so the board of our company can appoint any person as his substitute, as his alternate, and such director is called as alternate director. Is this clear to everybody? So that is called as alternate director. But you saw again he is appointed by board only. In additional director, was there any such requirement of substitution, alter, nothing like that? It was addition to existing directors. So appointed by board, appointed by board. But whenever you see a director remains absent from India for a period of not less than 3 months, therefore board has appointed someone as his alternate, such director will be called as alternate director. Otherwise, in general, when you see in case study question, director appointed by board, what you will say? Additional director. Generally, when you see director appointed by board, you will call it as additional director. But when you see director is absent from India, therefore board has appointed someone, then you will call it as alternate director. Is this clear? Come on, when can board appoint any person as alternate director? Only if authorized in AOA. Again, only if so authorized by AOA. Easy? Everybody understood? Okay? Yes. Alternate director shall hold the office for how much time? Alternate director shall hold the office. Come on, can I say he's substitute? He's alternate of someone. So once the original director returns to India, he will have to vacate his office. Correct? What if the original director does not return to India? If he does not return to India, so this person will continue to hold the office for lifetime? No. So he will continue to hold his office up to the expiry of the tenure of original director. So alternate director shall hold the office up to the day when original director returns to India, or up to the expiry of tenure of original director, whichever is earlier. Clear? Sorry? No. Because he is substitute. There is no intention to appoint him for the longer duration. That's what I told you, he is appointed by board. Okay? For किस लिए? अरे बेटा लॉजिक तो बता किस लिए? ही इज अल्टरनेट. एक मिनट, ही सब्सटीट्यूट. मैं आपको बताता हूँ आपका आंसर. ही सब्सटीट्यूट ऑफ सम डायरेक्टर. वो आ गया तो तुम किसी दूसरे के कुर्सी पे बैठा था, वो कुर्सी अभी खाली है क्या? नहीं. सो यू हैव टू वेकेंट वंस ही रिटर्न्स बैक टू इंडिया. करेक्ट? नाउ जैसे आपने बोला कि उसका काम अच्छा था, so you want him to be appointed as a director in the company. So in that case, he is appointed as a director just like any other director in general meeting. Then how he is alternate director? How that is called reappointment? When you say alternate director reappointment means he is substitute director, no? So if you want to appoint him as a director, you can appoint him separately. But once the original director returns to India, he will have to vacate his office because he was using the office of some other director, no? Understood? Fine. Let us conclude this. Come on. First, alternate director is appointed only and only when any director of our company remains absent from India for a period of not less than 3 months. Who appoints alternate director? Board appoints alternate director. When can board do this? Board can appoint alternate director only if authorized in AOA. What if AOA does not permit this? What if AOA does not allow the board to appoint alternate director? Then what to do? So you can alter AOA. You can alter AOA and then you can appoint a person as alternate director. Simple? Yes. Alternate director shall hold the office up to what time? Only up to the day when original director returns to India, or up to the day that is expiry of the tenure of original director, whichever is earlier. Easy? Everyone? Okay. 2 more points. First, tell me if a director who is absent from India is independent director and now you want to appoint substitute for independent director. So now what will happen? Come on, can you appoint an alternate director for independent director? Yes. Now if a person is appointed as alternate director for independent director, means this alternate director should also act independent. Means he should also satisfy the eligibility criteria of independence that is given in section 149 subsection 6. Correct? Easy? Okay, last point. A person can act as alternate director for any one director only in a company. In one company, you can act as alternate director for any one director only. For other companies, can you become alternate director? Yes, no problem. What was the doubt? A person can become director in how many companies? You have answered your question. Because in section 165 it is said that a person can hold maximum directorship in 20 companies including alternate directorship. It's written over there. Understood? Clear everybody? Sure? Fine. So all these points are already done. Can you see this? If a director is absent for not less than 3 months from India, right? All these things. These are the conditions which I already told you. Authorized in AOA or by passing a resolution by the company in general meeting, right? He is appointed in a place who is absent for not less than 3 months from India. Okay, yes, then he should hold alternate for any one director only. If he is acting as alternate for independent director, he should also satisfy the requirement of 149 subsection 6. Who can appoint? Board can appoint. Correct? Yes, this is all done. Okay, one more point I want to discuss. Okay, I'll do that. First, how he will be appointed? Obviously by passing a board resolution. What will be his tenure? We have already discussed. See this automatic reappointment. What is this? See, this alternate director is substitute of other director. Correct? The original director is outside India. Therefore is appointed here in India. Right? Now, just now we spoke about his tenure. So, alternate director shall hold the office only up to the day when original director returns to India or up to the expiry of his tenure. Correct? Now, suppose original director is outside India only. Therefore, he will hold the office only up to the expiry of tenure of original director. Correct? But now, what if that original director is still outside India and now you were appointed on his behalf as a substitute? Okay. Now, what if that original director, after expiry of his tenure, is eligible for automatic reappointment? If that person who is outside India, original director, was eligible for automatic reappointment. Understood? So now tell me, here in this company, the original director's office is getting expired? No. He is eligible for automatic reappointment. So now the point is, what about this alternate director? Come on, we told that alternate director shall hold the office only up to the expiry of the tenure of original director. But now that original director is eligible for automatic reappointment. So now the point is, will this alternate director also be eligible for automatic reappointment? Answer is no. So automatic reappointment provision is applicable to original director and not to the alternate director. And one last point, here we are saying that he's appointed by board. He's appointed by board means he is appointed by passing board resolution. But now tell me, is appointed by passing board resolution in board meeting or without board meeting? In board meeting or without board meeting? Anything is okay. I hope you know board resolution can be passed in board meeting also and by circulation also. So anything is okay here. By circulation, वो क्या होता है क्या? Section 175 board meeting chapter. Revise and come. Don't come and revise. Okay. Okay, so with this we are done with all the points of alternate director. Now we are moving to subsection 3. 161 subsection 3, that is nominee director. Come on. What is nominee director? Yes. Very interesting. Generally, directors are appointed by members of company in AGM. But here we did 2 points, additional director, alternate director, there is a director appointed by board. But here, nominee director is a director who is nominated by, that is recommended by third party, outsider. Understood? Recommended by them. So any outsider will recommend a person to be appointed as nominee director and the board of our company will appoint him as nominee director. Now the question is, why that outsider, why the third party is recommending our board to appoint a person as a director? Because that third party is having some interest in our company. That third party is having some interest in the company. Example, if our company has taken some loan from third party, from any bank, financial institution. Now to protect the interest, that financial institution has recommended a person to be appointed as a director in our company's board. Now our board is going to appoint him as a director, and that director is called as nominee director. Are you getting it? So what is the uniqueness here? He is a director recommended by third party. Easy, everybody? Any doubt in this? Sure? Okay. There is one more thing. This type of director, nominee director, cannot be removed under section 169. What is 169? Removal of director. So, when we study removal of director, nominee director cannot be removed, okay, by passing any resolution. So it's only this much, very simple, right? Then next we have is subsection number 4, 161 subsection 4, that is casual vacancy. But before that we have one small topic called as professional director. Have you done this topic in class? No. Why no? Because there is no such thing in Companies Act. Okay, can you see this? Professional director has not been defined in Companies Act 2013. So who is called as professional director? A person who is holding the position of a director in a company. Along with that, he is also a practicing professional. So such director is called as professional director. Yes, can you see that? Professional services by a director. Okay, professional qualification in relation to managerial remuneration. Clear? And your dictionary defines who is a professional. Fine, so we are coming back to our section series 161 subsection 4, that is talking about casual vacancy. Please concentrate, everyone. What is casual vacancy? What is the meaning of this term casual vacancy? The answer is, whenever a director who is appointed by the members, vacates his office. Understood? Whenever there is a vacancy of office of a director who was appointed by the members of company, shareholders of company, so tell me, that vacancy is called as casual vacancy. Understood, everybody? Once again, director appointed by the members of company, by the shareholders of company in AGM, vacates his office. If such director vacates his office, such vacancy is called as casual vacancy. So now suppose if there is a vacancy, suppose if there was a director, Mr. A, who was appointed by shareholders in AGM. Okay, he was appointed by shareholders in AGM. Now he was appointed by shareholders, so therefore he is going to enjoy the tenure of entire 5 years. Now what if he died? Now there is a vacancy. Is this a casual vacancy? Is this a casual vacancy? He was a director appointed by shareholders. Therefore this is a casual vacancy. Any doubt in this? Very simple. Now who can fill up the casual vacancy? Means now new director will be appointed. So who can appoint new director? Who can fill up this vacancy? Answer is board of directors can fill up this vacancy. Means board can appoint a new director in this place. You understood? Now if board appoints a new director in this place, tell me which type of director will be called as? Is he an alternate director? Is he an alternate director? Alternate director is used only and only when director is absent from India for a period of not less than 3 months. Here I am saying there is a vacancy. Director died. So therefore another director is appointed by board. So therefore he is a director appointed by board and is called as additional director. Are you getting my point? Remember one thing, come back to casual vacancy. There is a vacancy of a director who was appointed by members. If such type of director vacates his office, such vacancy is called as casual vacancy. Are you getting my point? Such vacancy is called as casual vacancy. Okay. Now who can fill up the casual vacancy? Board can fill up casual vacancy. Remember. And one more thing, board can fill up only and only casual vacancy. No other vacancy board can fill up. Board can fill up only and only casual vacancy. So board appointed Mr. B as a director and filled up that vacancy. Now tell me, is Mr. B going to enjoy the tenure of entire 5 years? Is Mr. B going to enjoy the entire tenure of 5 years? No. Why? Because he is director appointed by board. So he shall hold the office only up to the date of next AGM. Correct? But what happened, Mr. B was appointed by board. Board filled up the vacancy. Mr. B is appointed. Now Mr. B was enjoying his tenure. He was enjoying his tenure. Before AGM, he died. Before AGM, he died. So again, there is a vacancy. Tell me, is this a casual vacancy? Is this a casual vacancy? Is there a vacancy? Yes. Is there a casual vacancy? No. Why? Because what is casual vacancy? Casual vacancy means vacancy of a director appointed by the members of company. Mr. B was a director appointed by the board. Are you getting it? Therefore, such vacancy is not a casual vacancy. Therefore, can board fill up this vacancy? No, board cannot fill up the vacancy because board can fill up only and only casual vacancy. Clear? क्या चक्कर आ गया? सब इंपॉर्टेंट है. सर सोचो, मैं रिवीजन में इतना चैप्टर को लेके बैठा हूँ आराम से. मतलब ये बहुत इंपॉर्टेंट चैप्टर है. समझ रहे हैं आप? इसमें यू कैंट लीव एनीथिंग. Everything is interesting. You have to develop your interest, so everything is interesting. चलो ठीक है. Can we go further? So we are done with all 4 subsections. 161, all 4 subsections. चलो. Online, everyone is clear? कैजुअल वैकेंसी का टेन्योर तो डायरेक्टर का होता है. He is additional director. Who can fill up the casual vacancy? Board can fill up only casual vacancy. So if board is filling up only casual vacancy, board is appointed a person as a director, and he has filled up the vacancy. Correct? Now in that case, he will enjoy the office only up to the next AGM. And what if he dies before that? Again there is a vacancy. Is that a casual vacancy? So board cannot fill up that vacancy now. Chalo, let us continue. So, yeah, there is a doubt. Professional directors are not appointed by board. Beta, there is no provision only in Companies Act. देखा ना आपने, it is not defined in Companies Act. So there is no such rule. He is just a director who is having the professional qualification and he is also providing such professional services to the company. Such director is called as professional director. Okay, yes, so what is the next section? See this. Next one is section 162, in which they are talking about appointment of director to be voted individually. What is this? See, whenever a resolution is passed in the company, resolution of passed in the meeting, general meeting, for appointing a director, correct? So in this case, what will happen, friends? In one resolution, in a single resolution, you can appoint one director only. A single resolution, okay, shall not be moved for appointment of two or more person as a director. Means a single resolution cannot be passed for appointing two or more directors in one resolution. Means in one resolution you can appoint only one person as a director, not more than one. Is this clear to everybody? Because if a resolution is kept, so in that, if suppose two names are written, Mr. A and Mr. B, we want to appoint both as a director. Come on, please cast your vote. So now what if I want to, what if I want Mr. A to be appointed as a director and if I want Mr. B not to be appointed as director? So how will I vote? So therefore, a single resolution shall be moved for appointment of any one director only, not more than one. So therefore they are saying that appointment of director to be voted individually. Okay, is this clear? And if you want to appoint more than one director by a single resolution, then what you need to do? You need to first pass a separate resolution for this thing. Understand one thing. If you want to pass a resolution, single resolution for appointing more than one person as a director, which is not allowed under 162. So for that, if you still you want to do that, you can do that by passing a separate resolution. For separate approval is required for that. Can you see that? Unless a proposal to move such a resolution has first been agreed to at the meeting without any vote being casted against it. Yes, not a single vote should be casted against it. All the votes must be in favor. Only then this can be done. Otherwise it cannot be done. Very simple thing. So these are the two things. First is this. Second is this. Yes. किसका किसका तो ये झूठा लाइफ है. This is not real, you meant to say. 1 minute. क्या बोल रहा है? We are here to discuss what is written in law. मैं आपको इतना बोलेगा, if you jump a traffic signal there is a fine. But sir, मैंने तो jump किया था, मेरे को कुछ नहीं हुआ. That is system का problem. You understood, no? So what system is having problem, वो अपन बात नहीं कर रहे. अपन ये discuss करने बैठे हैं what is written in law. बस वो कितना follow हो रहा है, कितना नहीं हो रहा है, वो अपना टॉपिक ही नहीं है. So we should not talk about that. Understood? कुछ भी लॉ रहेगा, अरे उसने तो तोड़ा था, क्या फायदा इसका, ऐसा नहीं. रिलैक्स. ओके, चलो. ऐसे तो द पर्सन हु किल समवन, इवन अ मर्डरर गिव्स समटाइम्स गुड जस्टिफिकेशन फॉर किलिंग समवन. इवन अ मर्डर इज जस्टिफाइड, है ना? तो क्या बोलेगा, मर्डर माफ है? हाँ, तो ऐसा. Come on, let's go. Now, I hope you know what we have discussed just now. You please don't go out of the topic like this. I thought you were asking me something about the topic. Okay, so 2 points in this. But this provision is not applicable to certain companies. Okay, you can see this: private company, specified IFSC, public company, government company in which 100% holding is with the government, subsidiary of a government company, right? Where the entire 100% is with the government company. So for these companies, it is not applicable. Fine. Next, let's go further. Now again, you will see all the directors which we did earlier. That is first director, right? Then you will see additional director. Everything same. So why they are explaining it again? This is nothing but the procedure for appointment. Like as I told you, additional director is appointed by passing board resolution. So they will give the procedure for holding board resolution, holding board meeting, pass board resolution, appoint him, right? Then once he's appointed, you need to file form DIR 12. So same thing you can see here, the procedure, see this DIR 12 with ROC and all. Then enter his name in the register of directors and KMP. You know there is a register of directors and KMP also. As companies maintain ROM, register of members, there is also something called as register of directors and KMPs, which company maintains under section 170. Okay, so that is the point. Then you can see here procedure for appointing a director under casual vacancy, 161 subsection 4, right? Procedure for appointment of alternate director, again by board, right? Appointment of director by tribunal. Yes. Tell me one thing, can NCLT appoint a director in our company? When will NCLT do that? When will NCLT appoint a director in our company? That is when NCLT is of the opinion that there can be some mismanagement in the company. So therefore, to prevent that, NCLT may appoint a person as a director in the board of our company. Okay, so that can be done by the order of NCLT. Nominee director appointment again, right? Then appointment of director by small shareholders. This is also done. So these are the procedures for that. Then appointment of directors by the members at general meeting. Generally, who is appointing directors of company? Members in AGM. So this is that basic. But then here we need to go with is procedure. Okay. Procedure. Then this. Yes, this one. This is your section number 160, the next section. Otherwise, till now, everything was kind of repetition, which was given in the form of procedure. Okay, chalo. Now what we are talking here is section 160. That is appointment of person other than retiring director to stand for directorship. Do you know what is this? Come on, tell me. Can any one of you become director of company? Yes. Can any one of you can stand for directorship in a company? Yes. So here we are talking about a person who is appointed as a director, and that director is other than retiring director. Means a new person is standing for directorship. So how can he stand for directorship? Do you remember that? Come on, any person who wants to become a director of company, he needs to do what? He needs to send a notice to the company. Yes, he needs to send a notice to the company not less than 14 days before the date of meeting. He will send a notice in writing. In that notice, he is going to explain his candidature as a director. You understood this? He is going to explain his candidature as a director. Why he should be appointed as a director, he is going to explain that. Okay? Also, he is going to propose himself as a director, right? And then he is also going to give a declaration that he is not disqualified to act as a director. He is also going to mention his DIN number in it. All these things he is going to write in the notice, and he is going to send this notice to the company at least 14 days before the date of AGM. So that's all. We just have to send a notice to the company. Then what will company do? Company will send your details, that is details of candidate, to the members. Then in AGM, voting will be held. If you get the requisite votes, you are appointed. You are appointed as a director. Easy? Yes or no? Good, na? So what are you waiting for? Start writing notice and start sending notice to all the companies. You may be appointed someday, right? So it is not that. Along with this notice, you also have to give a deposit money. That is to avoid the non-serious ones. Okay, so notice must come along with a deposit amount of 1 lakh rupees per application or such higher amount as prescribed by the company. Yes, if suppose any company says that if you want to apply in our company, you need to give how much? You need to give deposit of 5 lakh rupees. So for that company, you need to give deposit of 5 lakh rupees. Now suppose if you give an application along with the deposit money, now in AGM, if you are not appointed, so in that case, what will happen? Your deposit amount will be forfeited. You won't get your money back. And if you're appointed, this deposit amount shall be refunded back to you. If you are appointed, the money shall be refunded. Are you getting the point? It shall be refunded if such person is elected as a director. And what if you are not appointed? You won't get your money back. But if you are not appointed, but if you get good number of votes, what is good number of votes? If you get more than 25% of total valid votes. If you get how much? How many votes? More than 25. Don't say 25. It is more than 25% total valid votes. In such case also amount shall be refunded. Are you getting this point? Okay. Now next thing. The requirement to submit the deposit is not applicable. The requirement of deposit is not applicable in which case? In case of appointment of independent director. You understood? In case of appointment of independent director or a director who is recommended by NRC, Nomination Remuneration Committee, okay, or a director who is recommended by the board of company. So for such directors, deposit amount is not required. No need to give deposit. Come on, which directors? Directors who are independent directors. When we are talking about appointment of independent directors, then director who is recommended by NRC or recommended by board. Such directors are not required to pay deposit money. Okay. Now this section 160 means the entire this process is not applicable on certain companies. Which companies? So firstly, it is not applicable on private companies. Okay. It is not applicable on private companies. It is not applicable on government companies where entire holding is with the government, any of the government. Okay. And also subsidiary company of government company in which the entire holding is with the government company. So these three companies, no need to do this. Okay. And last is in case of section 8 company, the rules are not applicable in case AOA provides for appointment of director by postal ballot. So if the articles of association of section 8 companies allowing appointment of director by postal ballot, this procedure is not applicable. Okay, easy? Yes. So this was the thing, right? And here you can see the procedure of the same again. You can see here, see the candidate who wants to stand for directorship. What he can do is required to give a notice in writing not less than 4 days before the meeting, explaining his candidature, right, consent, and along with that he need to give a deposit of 1 lakh rupees, right, or such higher amount as prescribed. That amount shall be refunded if the person is elected as a director. Requirement is not applicable, same if recommended by NRC or recommended by board, same thing. Correct? Yes. Now company has received your notice. Now what will company do? On receipt of notice, company will send your details to the members so that members can read your details, and when they come for your AGM, they're ready with their votes. Correct? Yes. So they will send your details to all the members. How will the company send your details to the members? By sending individual note. If individual notice is not possible, then company will publish the notice not less than 7 days before the meeting, in at least two newspapers, that is English and vernacular. Easy? Every clear? Everyone? Yes, then we'll check the DIN number and all. Once he's appointed, you need to take his consent, inform DIR2 to act as a director. Right? If you are a listed company, you need to inform stock exchange also. Send the notice copy to stock exchange. Can you see this? A person is appointed as a director, company shall refund 1 lakh rupees deposit. Already we have discussed this. And you will file form DIR 12 with ROC. This is always done within 30 days to ROC whenever a director is appointed. Is this clear to everyone? So you can see the list of attachments, letter of appointment, declaration and all. Okay, it's done. And again you can see your appointment of independent director. Yes, but already we have done independent director once, including eligibility criteria also. So you can read this again once about independent director. Reappointment also we have done. But this thing, please concentrate now. Something different thing, already we have done this in classroom module. See what is this. Everyone concentrate. Yes. You know, if I am a company and if I want to appoint an independent director, so I need a person who satisfies the requirement of 149 subsection 6, which contains so many points. So where should I go and find this type of person who satisfies 149 subsection 6? Where should I go and find a person who satisfies the eligibility criteria of independent director? Where should I go? So answer is, MCA maintains a data bank of independent director. MCA maintains a data bank of independent director, means any person who wishes to become an independent director is required to enter his name in this data bank. He needs to register himself in this data bank, and MCA will note down his name in the data bank of independent director. Okay, so can you see this? Every individual who has been appointed as independent director in a company, okay, or who intends to get appointed as independent director in a company, he needs to apply online on the website of the institute, that is IICA, that is Indian Institute of Corporate Affairs. This is institute which functions under MCA. This institute maintains a data bank of independent director. Okay, so you need to enter your name in this data bank by making application to this institute. Can you see this? For inclusion of name in data bank, you can add your name in the data bank for a period of 1 year, 5 years, or even for the lifetime. If you have entered your name in the data bank for 1 year, you need to renew it, right? Yes, from time to time you need to look for the renewal also. This is the institute I told you, IICA. Okay, yes. Then any individual, okay, including an individual who is not having a DIN, may voluntarily apply to this institute and enter your name in the data bank. Understood? So what will companies do? If company wants to appoint independent director, company can take any of the person from this data bank and appoint him as a independent director. But you know what? MCA takes the responsibility of maintaining this data bank, but MCA does not take the responsibility of accuracy of this data. Means it is clearly saying that company, before appointing any person as independent director, you should verify the details of the person. Okay, so that is the point here. But you know what, I told you, you also have to file an application for renewal, because if you have added your name for 1 year, so before expiry of 1 year you need to apply for renewal. After 5 years you need to apply for renewal. But if you have added your name for lifetime, then obviously you don't have to apply for renewal. Okay, so when should you apply for renewal? Within 30 days from the day of expiry of your period. Okay, and failing which, if you don't renew it, your name shall be removed from the data bank. Okay, and an individual who has applied for lifetime, no renewal is required for him. Easy, everybody? Yes. Then one more thing. You know, your name is not added in the data bank like just like anybody can just go and add their name. It is not that. You need to clear one proficiency test. You need to clear one online test, proficiency test. If you clear this exam, your name can be entered. And also you can clear this exam after your name is added. Okay, so your name will be added, but you need to clear that exam. Or you can add your name after clearing that exam. Okay, so what it is, see this. Firstly, every independent director shall, at the time of making application to this institute, what you need to do? You need to submit a declaration of compliance related to eligibility criteria. You need to give a declaration that I satisfy all the requirement of 149 subsection 6. You need to give that type of declaration. Okay, and every individual whose name is included in the data bank, every individual whose name is added in the data bank, he need to pass online proficiency test conducted by this institute within a period of 2 years from the time your name is added in the data bank. Understood? If you don't clear this test within 2 years, or if you fail to clear the test, your name shall be removed. Okay, to clear this test, how much percentage is required? So it is not less than 50% in aggregate in this online proficiency test. And if suppose you don't clear this exam, you can give it again, because there are no limit on the number of attempts. Easy? So this was about the online test, correct? You know what? There are exemptions also. There are exemptions also. There are a few people who are exempted from clearing this online proficiency test. Who are those? So any individual who has been acting as a director, KMP, okay, in any of the companies, no need to pass that exam. Fair? You are working as this positions in so and so, yes, associations. Then if you are a person who has been having the sufficient experience as working as an advocate, practicing CA, practicing cost accountant, practicing CS, you have experience of at least 10 years, shall not require to pass this exam. Okay, so obviously you need to learn this exemptions. So this was something new about your independent director. Okay, and now the new part is getting started, that is 164, that is about disqualification of director. Okay, we'll do this after a break. Okay, we'll continue this after a break, and then we will finish this chapter today, and then again today also we are going to solve some questions. Okay, so see you after a small break. Thank you. चलो, so next section is 164 disqualification of director. आपको पता है फ्रेंड्स, इसके अंदर दो सबसेक्शंस है, सबसेक्शन 1 एंड 2. अभी इसमें क्या बोला है, जिस भी पर्सन को कंपनी में डायरेक्टर बनना होता है तो उसे हमेशा क्या देना होता है, एक डेक्लेरेशन देना पड़ता है. पर्सन हु becomes a director of company, he needs to give a declaration. क्या declaration देगा वो? That he is not disqualified under section 164. तो what are the disqualifications of director? चलो देखते हैं. सबसे पहले subsection 1 क्या बोला यहाँ पे? Person shall not be eligible for appointment as a director if उसने क्या क्या किया तो he is not a eligible person to become a director. चलो देखते हैं. सबसे पहले, if he is of unsound mind and the same has been declared by court. If he is undischarged, insolvent, मतलब अभी भी वो क्या है, insolvent है, उसका insolvency खत्म नहीं हुआ है, मतलब declared as insolvent. फिर if a person has applied to be adjudicated as insolvent and his application is pending, मतलब पर्सन ने क्या किया है, अप्लाई किया है इंसॉल्वेंसी के लिए लेकिन उसका एप्लीकेशन क्या है, पेंडिंग है. तो अगर अप्लाई भी किया ना तो भी डिस्क्वालिफाइड टू बिकम अ डायरेक्टर. Okay, then if a person has been convicted by court for any offense, okay, you have been convicted by court for any offense and sentenced to imprisonment for a period of not less than 6 months. तो अगर आपको जेल की सजा हो जाती है कितने टाइम के लिए, नॉट लेस देन 6 मंथ्स के लिए, मतलब 6 से कम नहीं, मतलब 6 और उससे ज़्यादा, so it is 6 or more months. So in such case also you are disqualified to be a director. But let's say for example, if you have been sentenced to imprisonment for any offense and you have been sentenced to imprisonment for 2 years, so is that 6 or more months? Yes, it is 6 or more months, right? So once you go to the imprisonment, once you are released, now are you eligible to become a director? Once you are released, now are you eligible to become a director? What do you think? Yes, no? The answer is you are still not eligible, because 5 years has not lapsed from the date of your release. So means once you are out of imprisonment, again you need to wait for a period of 5 years. Till 5 years you are not eligible. Okay, is this clear? So if a person is sentenced to imprisonment for a period of not less than 6 months, so he is disqualified, and once he is out, again he remains disqualified only for a period of 5 years. Clear everybody? But if a person has been convicted for any offense and sentenced to imprisonment for a period of 7 or more years, if a person has been convicted for how much time? 7 or more years, such case you are not eligible to become a director in any company anytime. Means you have done such a offense, such a big offense, that you have been sentenced to imprisonment for a period of 7 or more years, right? So previous point was saying that if you have been sentenced to imprisonment for a period of not less than 6 months, means 6 or more months. But if that imprisonment period is 7 years or more, then you cannot become director anytime in any company. And in the previous point, it was once you are released, after 5 years, you are eligible. But here, you are not eligible anytime. Easy? Okay? Yes. Next, by the order of court or tribunal. That is, if any court or tribunal passes an order of disqualification on you, like the order is, means as a punishment order is passed on you that you are disqualified from becoming a director. So in that case again you are not eligible. Okay? Then next is, if a person has not paid call money on shares held by him, if you have subscribed the shares and you have not paid call money on shares, you know, first call, second call, you have not paid the call money, and okay, whether those shares you are holding alone or jointly, doesn't matter, this rule will be applicable. Okay, and 6 months has been lapsed from the due date of such payment. You understood this point, everybody? 6 months has been lapsed from the due date, so now you are disqualified. Means if you fail to pay the call money, okay, on the shares held by you alone or jointly, and 6 months has been lapsed from the due date of such payment, means can I say until 6 months are lapsed you are not disqualified, You will be disqualified once the 6 months are lapsed. Okay, the next is if you have been convicted for any offense under section 188, that is related party transaction, at any time during the last 5 years. If you have been disqualified, you have done any offense under section 188, 188 related party transaction. You have done this non-compliance in any time in preceding 5 years. Means any time in 5 years, if you have done this, you are disqualified. I hope this is clear to everybody. Yes, yes. Then, so there are total how many points? 8 points. See this. 1, 2, 3, 4, 5, 6, 7, and 8. Now what is these 2 points? What are these points? These are the points which you have already done somewhere. Like if you remember 152, then you remember 165, first director of company, then number of directorship in a company. So you can become director in maximum 20 companies only. If you want to become director in more than 20 companies, you are not eligible. You are disqualified, right? So friends, these many points are your subsection 1. Okay, subsection 1 talks about disqualification for appointment of director. But now here you can see subsection 2. What is subsection 2? It is a bit unique. In subsection 2 there are only 2 points. Okay, see, in subsection 2 you discuss about disqualification for reappointment. Subsection 2 is regarding what? Disqualification of reappointment. And what was subsection 1? Disqualification for appointment. Now it is different. See, understand. Under subsection 2, how many points are there? Only 2 points are there. Correct? So under these 2 points, you will see that person is already a director. Person is already a director in a company. Okay? And if you fall into any of the 2 categories, you are already a director in a company, and if you fall into any of the 2 points, then you are disqualified. But under subsection 2, when I talk about any of these 2 points about disqualification, in this case, once you are disqualified, you have to continue your tenure. Under subsection 2, you don't have to vacate your office immediately. You have to complete your tenure, and because subsection 2 talks about what? Subsection 2 talks about disqualification for reappointment. You understood this point? So, once your tenure is over, you cannot be appointed in that defaulting company. So, what is subsection 2? Let's see. See. Okay, a person who is already a director in a company, you are already a director in a company which has not filed financial statements, annual returns for a continuous period of 3 financial years. So that means you are a director of this kind of defaulting company. So in that case, what will happen? Come on, you are director of that company. So do you have to vacate your office immediately? No. Do you have to continue your tenure? Yes. And once your tenure is over, you cannot be reappointed. And remember one thing, under subsection 2, under these 2 points, person is disqualified from appointment in the defaulting a person is disqualified from reappointment in the defaulting company, and that person is disqualified from appointment in other company. One more time. See, suppose if I am director in 2 companies, Tata Motors also and your company also. Now your company is a company which has made default under this first point. Your company has not filed this financial statements or annual returns for a period of 3 financial years. So which company is defaulting company? Tata Motors or your company? Your company. I am director in both the companies, right? So now tell me, I am disqualified now. I am disqualified in your company for what? Appointment or reappointment? Reappointment means I can continue my tenure in your company. Can I be reappointed in your company? No. But what about Tata Motors? Person is disqualified from appointment in Tata Motors, and person is disqualified from reappointment in defaulting company. You understood? Means I will have to leave Tata Motors immediately, and I will vacate this company after my tenure is over. Because this disqualification, person under subsection 2 is disqualified for reappointment in the defaulting company, and person is disqualified from appointment in other company. So Tata Motors is other company. You understood? Okay, one more circumstance is here. If a person is a director of a company which has failed to repay deposits or its interest or repayment of debenture money or its interest or payment of dividend for any 1 or more year. So again, this is a company which has made default. What default? In the repayment of borrowed money or its interest, that can be in the form of deposits, debentures, or its interest or dividend. So if your company has made default under this or this point, you are disqualified under subsection 2. Easy? Okay? Yes. And once you are disqualified, then you are disqualified for lifetime? No. You are disqualified for a period of 5 years. From the date the said company fails to do so. Okay? Now, what if a person is newly appointed as a director? Okay, if a person is newly appointed as a director, he's newly appointed as a director in a company which has already made default under the subsection 2. You understood? There is a company which has already made default under subsection 2, and now I am appointed as a new director of that company. Can I say that company is already a defaulting company? Yes. Now I become a director in that company. As soon as I become a director, oh no, I am a director of a company which has made default. Come on, disqualified. Is it? No. I will not be considered as disqualified person because these defaults are not made by me. These are the defaults which company made before my joining. So in case of newly appointed director, this person shall not be covered under disqualification for a period of 6 months from the date of his appointment. 6 months from the date of his appointment. Is this clear? Everybody? Yes. And one more thing is, this subsection 2 is not applicable on government company. And one more thing is, for private companies, concentrate. Private companies, obviously, for the directors of private companies, all these points are same applicable. But private companies may add more disqualifications in its AOA. Private companies may add more disqualifications in its AOA for their company's director. Yes, that is in addition to those given in subsection 1 and 2. In addition to those, okay? So by its articles may provide disqualification for appointment as a director in addition to what is given in subsection 1 and 2. Is this clear to everybody? Right? So here we are done with subsection 1, subsection 2, and subsection 3. Easy? And with this, 164 is also over. Now we are going to the next section, that is 167, that is vacation of office of director. Vacation of office of director. What is this? Friends, in this section we are talking about a director shall vacate his office. Director have to vacate his office. Why? Is he disqualified? Under 164, that was about disqualification. Here it is more than disqualification. Means even if a person as a director is not disqualified under section 164, still he may have to vacate his office. Why? Because he did any of the following. So here are the circumstances given under section 167 where director have to vacate his office. Come on, director have to vacate his office. Yes, under the following circumstances. So what are the circumstances? Let's see. First one, if he incurs any of the disqualification given under section 164. Come on. If he's disqualified under 164, will he have to vacate his office? Yes. Okay. Next, if he remains absent from all the board meetings which were held during the period of 12 months, preceding 12 months, with or without seeking leave of absence. Everyone, do you know this point? We have done this point in chapter board meeting also. Correct? See, if you remain absent from all the board meetings, firstly tell me, is it necessary for you to attend all the board meetings as a director? No. Can you remain absent? Yes. But you need to communicate leave of absence to the CS or chairman. Correct? But if you remain absent from all the board meetings, let's say for example in the preceding 12 months 10 board meetings were conducted and you were absent in all 10. So now what will happen? You have to vacate your office. Okay? Yes. Next, do you know what is 184? 184, yes, it is again related to directors only. It is disclosure of interest. 184 is disclosure of interest. This section 184. So we have done that in 184 in the board composition chapter. That is, every director have to disclose his interest, like inform MBP1. Like if you are a director, member, partner in some partnership firm, or you are a director of some other company, you are a member of some other company, you are a member of some other association of person. So whatever connections you have to disclose your interest under section 184, inform MBP 1. MBP stands for meetings of board and its power, form number 1. Okay, fine. So friends, here the 167 says that if a person does contravention of 184, if a person fails to disclose his interest under section 184, then he will have to vacate his office. He will have to vacate his office. Simple. Then you also have to vacate your office by the order of court or tribunal. Okay, yes. And then the point is, if a person has been convicted for any offense involving moral turpitude or otherwise, and person has been sentenced to imprisonment for a period of not less than 6 months. Not less than 6 months means 6 or more months. If a person has been convicted for any offense for 6 or more months, such person is disqualified. He will have to vacate his office. Obviously, because now he is shifted to imprisonment. So he will have to anyways vacate his office. Right? So this is the point here. Okay? And then further, friends, here you saw there was one point called as you have to vacate your office by the order of court or tribunal. If suppose court has passed the order, vacate your office as a punishment. So now you are not happy with that order. So can you appeal? Yes, you can appeal. So here you can see the points of appeal. Okay? You can appeal within how much time and everything. So you can just read this once. Easy. Okay? Then next is again, private company may add in its AOA. May add in its AOA the additional grounds of vacation of office of director. You understood this? Just like section 164, I told you private company may add more disqualifications. Similarly, the list what we did here in 167, private companies may add more circumstances under which director have to vacate his office. They can extend the list basically. Okay, and here the point is, once the director vacate the office, so obviously director is leaving the company. And I told you, whenever director is appointed or whenever director is leaving, company is required to file form DIR 12 with ROC. Easy everybody? So again here also DIR 12 with ROC because he's leaving. Okay? And if a person who is liable to vacant his office under section 167. Okay, means he is liable to vacant his office under 167, and still he continues to hold the office, means he is not leaving the office. So there is a penalty. He shall be punishable with fine not less than 1 lakh rupees, which may extend to 5 lakh rupees. So minimum fine of 1 lakh, maximum 5 lakh. Easy? Yes, so after 167, we are moving next to 168. That is about resignation of director. Are you ready? See, removal is different, retirement of director is different, and resignation is different. Okay, so now we are talking about resignation of director. Everybody concentrate. So first thing is, tell me, how can director resign? 1 minute, 1 minute. All the students online, YouTube, are you all listening? If you have any doubt, you can just write it down on the live chat, please. Yes, and after finishing this lecture, please finish this chapter today itself. It is very important chapter. Okay? All the best. Chalo, let's continue. 168. Resignation of director. Now friends, how can director resign from office? Very simple. Director can resign just by giving a notice in writing to the company. Right? So director may resign from his office by giving a notice, right, in writing to the company. Easy? Yes. Now you know what? This resignation part 168, two things are there in resignation of director, section 168. First, what is the effective date of resignation? There are two things. One is the effective date of resignation, and another thing you need to do under this section is the compliance requirement. Okay, so first let us talk about effective date. Firstly, do you know effective date is very important? Why? Because director is sending a notice of resignation, that is okay, but what shall be the effective date of resignation? Means from which day director is set to leave the office. Okay, from which day director is said that he is having no connection with the company now. That means resignation will come into effect from which day. And you know why this effective date is important? Because it decides the liability of director. So what is the effective date firstly? Effective date is the director has given a resignation notice to the company. So there can be chances that director he may have mentioned the date of resignation. So director may have mentioned there, like for example, from 10th December, I resign. So he has already mentioned the date of resignation. So date which is mentioned by the director in the notice, date mentioned in the notice, or the date on which company receives the notice, whichever is later. Whichever is later. See, why later? Understand one thing. Hello, he gave a notice to the company. So he gave a resignation notice saying that I resign from effect 10th of December. Okay. Company receives that letter on 15 December. So resignation is effective from 15 December. Understood? Everyone? No, there can be delay in whatever mode they are sending. Whichever is later, you can talk otherwise also. Like for example, company has received the letter on 10th December and the date mentioned by the director is 15 December. So whichever is later. So that is the effective date, everyone. Okay. So effective date is clear. Okay. Now he has given notice to the company, to the board. Now what will board do? Board shall take a note of the same. Board shall take a note of the same. You understood? Okay. Yes. So effective date is clear. date when company receives the notice or date mentioned in the notice, whichever is later. Okay. Now you know what? Here, everyone, this means director will be liable for all the acts done in the company before effective date, and director shall not be liable for the acts done in the company after effective date. So effective date is important as it decides the liability. Easy? Okay. Now friends, this was about the effective date. Now we need to understand the compliance requirement. Come on, tell me who has received the resignation notice? Company. Now what will company have to do? Come on, director is being appointed or is leaving the company? Is leaving the company. So you know, whenever director is leaving the company, you need to file what? DIR 12. So here again, company shall file DIR 12 with ROC, that is within 30 days from the date of receipt of resignation. Okay, so company have to file Form DIR 12 within 30 days from the day company has received the resignation notice from the director. Easy? This was one thing. Another thing is that director who is resigning, the resigning director also have to file something. He will file Form DIR 11 within 30 days. Okay, with ROC. But you know what? Filing Form DIR 11. Firstly, this is filed by whom? Resigning director. Okay. Now, resigning director is filing Form DIR 11, but the resigning director filing this form is totally optional. Okay, director may within 30 days from his resignation file with ROC a copy of resignation along with the reason in Form DIR 11. Is this clear to everybody? Okay, so this is the compliance requirement. Company will file Form DIR 12, resigning director will file Form DIR 11. Filing DIR 11 is optional, and here they are talking about the effective date, which we have already done, and also they are talking about the liability. Can you see this? Liable for the action done. Okay, so with this is over. Next we are moving to section number 169. After 168, 169. Hey, you know one more thing? This resignation part, you know, resignation of a director can be a whistleblower. This act leads to whistleblower activity. How? You know that case, Satyam Computers? When something wrong happened, there were two plans. First plan was totally against the plan. First plan A was not working, therefore they started executing plan B. Now even plan B was flopped. So now what happened? Now directors were very much aware that now we are going to be under problem. So three independent directors, as soon as plan B didn't work out, three independent directors resigned the company. That resignation of three independent directors was a whistleblower, and all the authorities came to know about it, and now the founder surrendered himself to SEBI on 7th January, if you know, 2009. Okay. So now this, yes. So whistleblower effect, resignation of director carries whistleblower effect. Next is removal of director. Come on, see, removal is different. Removal means obviously company is removing a director, obviously before expiry of their period of time, before expiry of their tenure. Correct? So now friends, when company is appointing director, come on, who appoints the director? Members of company in AGM. So who can remove the director? Obviously the owners. Who are the owners? Shareholders, means the members of company, right? So company may remove a director by passing which resolution? Ordinary or special? Ordinary resolution. By passing ordinary resolution, you can remove a director. Is this clear to everybody? Yes, no? Okay. But before you remove this director, any director by passing OR, first you need to give opportunity of being heard. Right? Principle of natural justice must be followed. Correct? Yes. Next is, you tell me, what if company wants to remove an independent director? If company wants to remove an independent director can be removed by passing ordinary resolution or special resolution? Ordinary resolution only. Independent director can be removed by passing ordinary resolution only. But if company intends to remove an independent director who is reappointed, who is enjoying his second term of 5 years, if you want to remove such independent director, then company is required to pass special resolution. Because he is second time elected by the members. He is second time choice of the members. So you need special approval. OR is simple majority. That is special majority. Okay, so yes, you can see here, company may remove by passing ordinary resolution. You can remove a director. Okay, but you know what? Okay, I was talking about independent director. Yes, so an independent director who is reappointed for his second term shall be removed by the company only by passing special resolution and after giving opportunity of being heard. Everybody understood? Clear? Sure? Fine. Now listen to me. There are two types of directors which cannot be removed under this section. Which are those? One is nominee director, another is director appointed by tribunal. So these two directors cannot be removed. Can you see this? Not being a director appointed by tribunal. So you cannot remove a director. There is a doubt, how do we find that we should pass SR or OR? Better that is written in law. OR means simple majority approval. SR means special majority approval. So for few cases, they have law says that you need to pass special majority approval, that is SR. And there are few things for which only simple majority is also okay. So whatever is given in law, kind of approval you need to follow. Okay, done? Done. So here now you can see procedure for removal of director. We have done this in class. Yes, please concentrate everybody. What is this procedure? We have done this in class. You can see my notes step by step. You will see the procedure for this. But I'll go through it once. Concentrate. See, whenever a company wants to pass OR, SR, whatever we did, for removal of director. So OR or SR, in both the cases you need to take the approval of members in general meeting. Means you need to call general meeting. For calling general meeting, you need to give notice of general meeting. But here, law says that removal of a director is not an ordinary thing. It's a very big decision. To show the importance of this agenda, law says that company should not just give a notice to the members, but company should give special notice. Special notice to the members. You know, in the special notice, it is already written on that. On the notice page, it's written special notice. So when they see special notice, they can understand some important agenda is going to be transacted in the upcoming meeting. So what they will do, they will not remain absent. They may not appoint proxy and they themselves be present in the meeting. So for removal of director, company is required to give what? Special notice shall be given by the company to the members for passing a ordinary resolution for removing a director. Okay? So now for calling general meeting, special notice is given. Now what's next? So special notice is sent. Now you know what? Company will also send a copy of that notice to the director who is proposed to be removed. Understood? A copy is also given to the director who is proposed to be removed. Can you see that? Send a copy of special notice to the director proposed to be removed. When the copy is given to them, Copy is given to the director. Now that director is going to give his representation. Means now he's going to give his clarification. Okay. So he will give his clarification. He will give his reply to the company. Now it is the duty of company to send that reply of this director proposed to be removed. His reply should be circulated to all the members of company, or that reply must be read out at the general meeting. Company have to either send his reply to all the members, so that members should know what company wants to do and what that director wants to say. So accordingly members will vote. So that reply must be sent to all the members, or it should be read out at the general meeting in front of all the members. Everybody understood? So accordingly resolution will be passed. But you know what? If that reply contains anything which is irrelevant, anything which is inconsistent, anything which affects the reputation of company or any other person, so company, how will company send that reply to all the members or read out at the meeting in front of all the members if there is something which affects the reputation of company? So in such case, company can approach NCLT. Company will approach NCLT, and if NCLT is also of the same opinion that yes, there is something wrong in the reply, so in such case, company is waived off from that obligation of sending that reply to all the members or reading out that reply in front of everyone. You understood? Means now company is not required to send the reply to everyone, or company is not required to read out the reply in front of everyone. Everybody understood? Sure. So this was the point. Can you see this? Representation received. Yes, this is about the representation. Then NCLT is of the opinion. Then it is not required to be read out or sent to all the directors, all the members. Correct? Then company will hold the meeting, pass OR and remove a director. Now tell me one thing, the director who is removed, is he eligible to claim compensation for loss of office? Do you know compensation for loss of office? Yes, no? Which section? 202. We have done that in our first Sanjivani lecture in this series. That was the last topic of this KMP chapter. Okay, so yes, he is eligible to claim compensation under section 202. Correct? Now when we say 202, you know, it was very well given there that if he has done some fraudulent activity, if he has done something wrong, then he won't be eligible. So therefore we will give him as per 202. So as per 202, everything is covered there. Okay, easy. Yeah, we give him 3 years remuneration or remaining tenure remuneration, whichever is less. Correct? So he is eligible for that. One more thing. What if company, now there is a vacancy because you're removing him. But what if company intends to appoint a new director in the same meeting? You want to appoint a new director in the same meeting. You understood? Now that meeting has become more special. Because in that meeting, in that general meeting, you are not only going to remove a director, you are also going to appoint a new director in place of this removed director. Yes, everyone understood? Okay, so now what happened? Again, company is required to give what? Special notice for such general meeting. Again means not a separate notice, means for such general meeting, company is required to give special notice containing the details of the person who is proposed to be appointed as a new director. The person who is proposed to be appointed as a new director. Details of such person shall be there in the notice, special notice. So that when members come to attend the meeting, they are ready with the decision. They will inquire ready everything with the information of that new person, and accordingly they will vote. Okay. Now one more thing, friends. What if that new person is appointed? That new person is appointed in that meeting, new director is appointed in that meeting. What shall be the tenure of that director? Come on. Is he a director appointed by members? Yes. Therefore he is not an additional director. So what shall be his tenure? 5 years. Sure. But the point says that such new director shall hold the office Firstly, only up to the expiry of the tenure of the director who was removed. You understood? The director who is removed. So, this new director will continue the tenure of the director who is removed. Everybody understood? Yes, no? Okay. Now, uh, so after that remaining tenure gets over, can this person be reappointed? Yes, that depends on the members. But currently he will finish the tenure first. Okay, that's all. Yeah, then this is the steps. He is going, so DIR 12. Inform stock exchange within 24 hours if you are a listed company, right, and so on. Your section is over. Easy? Everybody? So next section is what? Next section is 185. Loan to directors. Very, very interesting topic. Right? We will go through this. See, this 185 is left. Then 184. Duties of director. Register of director. And then chapter is over. Okay? See, I purposely went very slow in this chapter because of the importance of this chapter. Okay? Chalo, let's go. Everyone on screen, I hope you know the chapters related to directors means I'm talking about three chapters: KMP, directors, and board composition. These three, and two chapters of meetings, board meeting and general meeting. These five chapters you should do everything from each and every word of your module. No shortcuts, please, no shortcuts. Okay, fine. So, can we start? Or 1 minute break? 1 minute break. You are always ready for break. Nothing wrong. अभी तो तू आया. Chalo, let's continue. Now, next section is section number 185, that is loan to directors. Please concentrate, very important section. इस सेक्शन को हम लोग यूं रिवाइज करेंगे. यूं कैसे? यूं. ध्यान से सुनो, खाली ध्यान से सुनो. आपको पता है कंपनी कैनॉट गिव लोन गारंटी सिक्योरिटी. कंपनी मतलब कौन सा कंपनी? जो कंपनी लोन दे रहा है. तो जो कंपनी लोन दे रहा है ना, the company which is giving loan will be called as lending company. For this particular section, I will name it as what? Lending company. Company which is giving loan. Okay. So what does law says? See, understand the concept. Loan to directors. Company is giving loan to its own directors. So is there any problem in this? Yes. Because if you see company is giving loan to a director. But who is running the company? Director only. So if you see this transaction like this, director is approving loan for himself. Are you getting it? So will director reject the proposal loan to himself? Obviously no. So he can misuse the power? Yes. Therefore subsection 1, section 185 subsection 1 is putting restriction. You know what does this subsection 1 say? Subsection 1 is saying that company cannot give loan guarantee security. Please concentrate. Our company means lending company cannot give loan guarantee or security. Cannot give loan, cannot give guarantee or security for the loan of someone else. Okay, so cannot give loan to whom? I told you, to its directors. That means director of lending company. That is its own directors. Okay. Also lending company cannot give loan guarantee security to the director of holding company of lending company. Means if our company is having a holding company, if our company is having a holding company, okay, so these are the directors of our holding company, correct? Now our company can give loan to its own directors. Board of directors can give loan to the own directors? No. Can our company give loan to the director of holding company? Answer is again no, because again the holding company's directors can create influence on our company and may approve loan for themselves, correct? Now see friends, here second point is also done. Third point, suppose director of our company Mr. A, okay, Mr. A is director of our company. Also he is having one business, okay, he is having some business. Mr. A is having some business and he is running that business along with Mr. X as partners. These both are what? Business partners. Okay, now see, understand. Can our company give loan to Mr. A? Can our company give loan to Mr. A? No, because first point says that company cannot give loan to its own director. Understood? Can our company give loan to Mr. X? Who is Mr. X? Is Mr. X director of our company? No, but Mr. X is a partner of director of our company. Yes or no? So loan cannot be given to a partner of director of lending company. Because understand one thing, if you see this transaction like this, company is giving loan to Mr. X. If you see this transaction like this, who is running that company? Mr. A. So Mr. A will approve loan for his own partner. He's not going to reject that proposal anyway. So therefore it is no, not allowed. Okay, what if I say Mr. X is a partner of not Mr. A but Mr. P. Who is Mr. P? This one. That is director of our holding company. Understood? Come on. So now what to do? Can our company give loan to Mr. X? Who is Mr. X? Partner. Partner of director of holding company of lending company. Understood? This is also not allowed. Because holding company director can create influence on this company and can create influence to pass loan for his partner. Therefore, not allowed. Okay, so loan cannot be given to the directors, loan cannot be given to the partner of the directors. Okay, next is, can our company give loan to relative? Can our company give loan to relative of director? Come on, relative of director of lending company. So obviously answer is no. Because if you see the and you know who is a relative? The definition of relative is given in Companies Act. The definition of relative is given under section 2 clause number 77. Sorry. 188 is related party transaction. Definition of related party is different. Definition of relative is different. Related party is defined in section 2 clause 76. Relative is defined in 77. Okay. So if you see this transaction like this, company is giving loan to Mr. XYZ. But if you see this transaction like this, director is approving loan for his own relative. So director may misuse it. Therefore not allowed. So loan cannot be given to the relative of director of our company. Also loan cannot be given to the relative of director of holding company of lending company. Okay, so this is about relative. And last point of subsection 1 is, if our company is giving loan to a firm. This time our company is not giving loan to a director or a person. This time our company is giving loan to a business, a firm. Okay, a firm in which director of our company, that is lending company, director of holding company of lending company, or relative of any of the above. Okay, a firm in which director of our company, director of holding company of our company, okay, or any of the relative is a partner in such firm. So if you see this transaction, our company is giving loan to a firm. But if you see the transaction like this, our company's director is approving loan for his own firm, or he is approving loan for the firm of his own relative. Therefore it is not allowed. This is your subsection 1, 5 points. Everyone is clear with this? Subsection 1 is over. Yes. You have these notes with you. You have that notes with you. You have my notes link. डायरेक्टर्स चैप्टर का नोट्स है, उसमें है ना. क्या तड़प रहा है? हाँ, क्या देखना, मिल जाएगा तेरे को. नहीं मिलेगा तो मैं दोबारा तेरे को लिख के देगा. डोंट वरी. वो क्या सब है, फिर भी बच्चे लोग कैसे ना टेलीग्राम से निकाल के लाते हैं. ठीक है. अभी वो भी जूना जूना, फिर आधा उसमें लिखा रहता है, आधा नहीं लिखा रहता है. फिर उनको मालूम पड़ता है आधा नहीं लिखा है, फिर बैठ के लिखते हैं. देखो, और ब्लैंक पेज इसलिए छोड़ा है वहाँ पे ताकि लोग लिखे. चलो फाइन. दिस इज सबसेक्शन 1. So in subsection 1 you saw there are 5 points. In all the 5 points, loan guarantee security cannot be given. To whom? To these 5 people. Okay. Now we are going to subsection number 2. One minute, tell me one thing. Why loan guarantee security is not allowed to them? This 5. Why loan is not? Because all these are interested parties. All these are having some way or the other way connection with the company. Therefore, directors may misuse the power. Therefore, not allowed. Correct? But you know what? In subsection 2, you will see our company is giving loan guarantee security to the 2 parties who are having interest. Still loan can be given. Let's see what it is. Okay. So first point carries 5. Now you can see this subsection 2 here. Okay. This point is saying that our company can provide loan guarantee security to whom? No. Our company means lending company can provide loan guarantee security to a private company in which director of lending company or director of holding company of lending company. Okay. So our company is giving loan guarantee security to a private company in which our company's director or holding company's director is a director or a member in such private company. You understood? Our company's director is director in such private company, or our company's director is a member in such private company. So obviously our company is giving loan to a private company which is having some way or the other way interest with our company. Yes. But still this is allowed. This is allowed if conditions are satisfied. What are the conditions? We will come to that part. But let's see. There is one more point. Our company can provide loan guarantee security to a body corporate. To a body corporate. Okay. Yes. What is body corporate? You know very well. It includes companies incorporated in India and also companies incorporated outside India, right? A body corporate in which not less than 25% of the total voting rights vest with. You understood? Out of the total voting rights, not less than 25% vest with director of lending company, that is our company, or director of holding company of lending company, or both together. Okay. Yes. If these people are having interest of not less than 25% of total voting rights in this body corporate, still our company can give loan guarantee security to this body corporate. You saw our company's director is having good amount of interest in this body corporate, still it is allowed, right? But it is allowed only if the conditions are getting satisfied. So both of this loan guarantee security is allowed only if the condition is satisfied. What are the conditions? First condition is you need to ask the owners of company. Who are the owners of company? Shareholders of company. That is, you need to pass special resolution in general meeting. You need to pass SR. Then this is allowed. Second, when you call this general meeting, obviously first you will send the notice of meeting. So when you send the notice of this meeting, you need to attach explanatory statement. Explanatory statement must be attached along with the notice of such general meeting. You know what is explanatory statement? Giving details of the transaction. Means everything will be mentioned in that. The amount of loan, what is the rate of interest, duration of loan, everything. Okay? So that members can accordingly be ready with their votes. And third condition is loan must be given for business purpose only. Loan must be given for business purpose only. You understood? So if these three conditions are getting satisfied, then our company can give loan guarantee security to this private company and body corporate. This is your subsection number 2. Easy? Everybody understood this? Yes. Can you see this private company and body corporate? Same thing. And here they have given the conditions. Can you see SR and all? Explanatory statement must be attached and it should be given for business purpose only. So first they have mentioned the conditions here and then to whom it is given. Okay? This subsection 2. Now subsection 3. See, understand one thing. You know there are two types of directors, executive and non-executive. So third point says that company may provide loan, guarantee, security to managing director, whole-time director. Who are these two? Executive director. Executive directors are the employees of company. Yes or no? Yes. So company can give loan. See, in subsection 2, loans were not given to the directors. Loans were given to the private company and body corporate, right? But here we are talking about directors now. Obviously specific directors, there is MD and whole-time director. So loans, guarantee, security can be given to them as per this or as per this. What is this as per this, as per this? That is, loan can be given to them as per the scheme. As per the scheme, you understand scheme? As per the terms and conditions, as per the scheme of loan which is approved by the members of company by passing SR. By passing SR, by passing special resolution. Understood? So the terms and conditions of loan should be approved by the shareholders by passing SR, or loan can be given to them as per the terms forming, as per the terms of loan forming the part of their employment contract. Forming the part of their employment contract. Come on, are these two the employees of company? Yes, these are executive directors. Only managing director and whole-time director is executive director. No other director is called as executive director, right? So yes, after the terms of loan, the loan can be given to these two as per the terms of loan which is mentioned in their employment contract. So it's as per the scheme which is approved by the members of passing SR, or as per the terms and conditions which is mentioned in their employment contract. So in this manner loan can be given to them. This becomes your third point. Right wala? What right wala? No, disclosure is given na dost. In the annual report, every time the directors are appointed, including the terms. Beta, who appoints the director? Correct. So by passing a resolution, everywhere you have read already in so many chapters that whenever the resolution is passed, it includes all the terms and conditions of their appointment, including remuneration. Okay, so as per this, now last point, what if company is giving loan in their ordinary course of business? It is a duty of company. The company is under the business of giving loans. So in that case, can company give loans to directors? Company is giving loan to everybody, so why not its own directors? So in such case, company can provide loan in the ordinary course of its business. Loan can be given, but will company give loan free of cost? No. Company will charge rate of interest? Yes. What rate of interest? Can I say rate of interest is income for the company? Income for the company. Yes. So, you know what shall be the rate of interest? So, rate of interest charged on such loan which is given to its director, that rate of interest shall not be less than the rate which company may have derived by making investment, the same amount investment in the government securities for the same tenure. The rate of interest which company could have earned by making investment in government securities for the same duration, same amount. So rate of interest charged on such loan should not be less than that rate of interest. So if you want to give loan to your directors, first you need to determine what rate of interest you will get if instead of giving loan you invest this money in government securities. So you have identified that, okay, I will get 7% for example. So now the rate of interest what you will charge on this loan to your directors should not be less than 7%. Easy? Everyone? Over. And if you give loan in contravention of this provision, then there is a penalty. Yes, boss. See, here we are giving loan to our own directors. So here we are talking about the relaxations. So generally we said that it is not allowed only. But in this way it is allowed? Yes. But if you are giving loan to your directors, why are we talking about this section? Because the director may misuse it. Because the director themselves are running the company. Right? They approve the loans. So if you see this transaction this way, director is approving loan for himself. Even if company is into the business of that, director is the person who is going to approve the loan. So he cannot approve the loan free of cost. Minimum rate of interest he should charge for his loan is not less than what he will get from government securities investment. Okay, so that way relaxation it is. Yes, otherwise they would have misused the powers. Fine, everybody, online. 185 is clear. ये खतरनाक सेक्शन था. इसको मैंने मेरे इंस्टाग्राम पे 1 मिनट में समझाया है. चलो फाइन, ठीक है. So 185 is also done. Now 184, then 166, then is almost chapter is over. Okay, everyone clear? So if all the online students clear हो चुका है, अरे एक बढ़ गया अभी. Good. चलो फाइन. Now next is 184. Wow. Nice. Disclosure of interest, 184. Okay. You know what is this topic about? I'll explain you this conceptually. Paragraphs are already given here, but let us understand conceptually. See, if today our board meeting is going on, so in board meeting who can attend the meeting? Only directors can attend the meeting. Yes. So I am also director in your company. So I am director in your company also. I am director in Tata Motors also. What is agenda of today's meeting? That our company should enter into contract with Tata Motors or not. Correct? So I am director in Tata Motors also and I am director in your company also. So today I am present at this board meeting in which we are going to approve, we are going to pass a resolution on Tata Motors contract. So what do you think? I am attending this meeting. Am I called as interested party? So what will be my vote? My vote will be yes only. In case if my vote will be biased. In case if I participate in this meeting, I am going to be biased. I am going to be partial. Because even if this contract is not in the interest of our company, still I would vote in favor only because this contract may be in interest of that other company, Tata Motors. and I am director in that company also. So therefore I am going to say yes only, right? So therefore, as the quality decision should come out of the resolution, there is section 184 who protects this kind of activities. This should not happen, because in company, amount invested by the investors, right? So to protect their interest, this section says that every director in a company, this is for every director in a company, should disclose his interest. Every director in the company should disclose his interest, means he will have to give the disclosure of his interest in form MBP 1. He should give his disclosure of interest, means he needs to inform to all other directors that I am director of so and so company, I am member of so and so company, I am partner of so and so firms, I am member of so and so association of persons. I need to give disclosure of all the interest, all the connections which I have with other companies, other firms, other association of persons. So I will give the disclosure of interest to whom? To all other directors. When? In my first board meeting. Means as soon as I joined the company, after that, first board meeting. And thereafter, first board meeting in every financial year. Okay. And also, whenever there is change in the disclosure which is already made. Like for example, if I have given disclosure of interest that I am director in your company and I am director in 5 other companies also. So I have given this disclosure. Now after I give this disclosure, next disclosure I will give in next year first board meeting. But during the year, if now I become director of 2 more companies, means now I am director in 7 companies. So there is change in the interest which is already disclosed. So again I have to give the disclosure in the next meeting immediately, which happens whenever it happens, next meeting after change in interest. Same MBP1, disclosure of interest in MBP1. Okay, so can you see this? First board meeting held after such change. Okay, so friends, every director shall first meeting of board, thereafter first board meeting in every financial year, or whenever there is change in the disclosure which is already made. So every director have to disclose his interest in any company, body corporate, firms, association of person, everything to all other directors. Is this clear? Okay. Yes. So you need to give the disclosure of all the body corporates, of all the firms, companies, wherever you are, director, member, partner, owner, everything you need to give the disclosure of. Okay. Yes. Then, how to give this disclosure? That is given here in the rules. Here it is. You need to give your disclosure of interest in form MBP 1. You need to give this in writing in form MBP 1. Okay, and all the disclosures given by all the directors every year shall be kept at the registered office of company, preserved for 8 years from the end of financial year in which the disclosure is given. Shall be kept in the custody of CS of the company or any other person authorized by board. Okay, so all these things are there. But friends, what if a director has not disclosed his interest and this resolution is passed, and now our company has entered into a contract with Tata Motors? Come on, I was interested director, I have not disclosed my interest, resolution is passed today in our meeting, and our company has entered into a contract with Tata Motors. So what do you think? Is this resolution which is passed, is this resolution fair? It is contravention of section 184. So what is the effect of that now? Will that contract which is entered between our company and Tata Motors, is that contract valid? First you tell me one thing, if there was no provision of 184 in Companies Act, so tell me who will be in problem? Company. Because the directors will misuse the powers. If there is no such rule, then why will director disclose the interest? So who will face the loss? Company will face the loss. Therefore, there is section 184. Correct? And you know what is 184 saying? 184 says that every director should disclose his interest and not to participate in the meeting. 184 says that every director should disclose his interest and not to participate in the meeting. This is his duty. You should not participate in the meeting. But I was talking about the circumstances where director failed to disclose his interest. He casted his vote also, resolution is passed, and our company has entered into a contract with Tata Motors in which I was having interest. Correct? Now what is the effect of that contract? That contract is voidable. It is voidable at the option of company. Means still we are giving option to the company. You know what is voidable, right? It may be valid, may be void. Currently it is not valid, not even void. So if company raises the objection, then that contract will become void. No objection, contract will be valid. You understood? So that is the effect of that. Plus, director will be penalized. First effect was contract is voidable. See here you will see. Plus, director will be penalized with fine of rupees 1 lakh. Where it is? Here it is. Fine of rupees 1 lakh. If he does contravention of subsection 1 or 2 of 184. Why? Why? Correct, but company is okay with the interest getting affected. So option is given to them. That's what, therefore I explained it in such a way. What if there was no such rule? Who was at loss? Company. Still, you know what? Even that related party transaction, if it is not followed, resolution is not passed, it is voidable. Company can ratify that within 3 months. If not ratified, it is voidable. It is at the option of company. That way it is. Okay, so contract becomes voidable, and secondly, director will be penalized with fine of rupees 1 lakh. You know one more thing, that the point which we did in 167, if director fails to disclose his interest, he will have to vacate his office. Do you remember that? That was this section only, na? Oye, 167. Where is 167? See this, see this, see this, see this. See this, can you see? If he acts in the contravention of 184, he fails to disclose his interest under 184, so he will have to vacate his office. Easy, everyone? So you understood the effect of contract as well as the penalty for directors. One more thing. What if I casted my vote today because, okay, I have not disclosed my interest because I don't have interest in Tata Motors. Suppose if I am participating in board meeting of your company, I am a director in your company, and if I have no interest in Tata Motors, so am I called as interested director? No. Can I participate in today's meeting? Yes. So I participated in the today's meeting. I casted my vote also. Resolution is passed. Okay. After passing the resolution in few days, now I became interested director. Means now I was appointed as a director in Tata Motors also. Means can I say at the time of voting, I was having no interest. So 184 applicable, not applicable? Not applicable. I was having no interest, so I can participate obviously. Can I say interest arised subsequently? So if interest is arised subsequently, so now what to do? The vote which I have casted, that vote remains valid or not valid? That vote remains valid, and now onwards, further, it is my duty to disclose my interest. And now further I will not participate in the discussion of that matter. Now further I will not participate in any of the discussions of that business matter in which I am interested party now. Easy? Okay, now under 184, what disclosures we need to give in 184 MBB1? What disclosure we need to give? You need to inform the name of the companies and body corporates wherever you are a director. You need to give the names of the companies and body corporates wherever you are a member. You need to give the names of the firms where you are a partner. You need to give the names of the association of persons like trust, this, that, wherever you are a member. Correct? You also need to give the list of your relatives. Wherever you are a relative. Who all are your relative? Give the list of your relative. Also give the names of the companies and body corporates where your relative is a member or a director. Give the list of the firms in which your relative is a partner. Are you getting it? Give the list of the association of persons where your relative is a member. So you need to give all this list, but you understood the first point. Second point I told, you need to give the list of the companies and body corporates where you are a member. Means you are a shareholder. So suppose if our company is having a board meeting today, I am not a director in Tata Motors, but I am a member of Tata Motors. Means I am a shareholder of Tata Motors. Okay. So if I have one share in Tata Motors, one share, 900 rupees, one share. So now, and I am director in this company. So come on, I am a member of some other company? Yes. And today we are going to discuss about that company? Yes. So what is my duty? To disclose my interest and get lost, not to participate. Just because of 900 rupees, I cannot participate in today's meeting, right? No. So the point says that if a director is having interest in the other company or body corporate up to 2% of the paid up share capital of that company, up to this limit, then section 184 is not applicable. Then section 184 is not applicable. Is this clear to everybody? Your entire 184 is over. One more thing I want to say. You know, in 184, in case of private companies, interested director can participate. Even if he is interested party, he can participate after disclosing his interest. Clear everybody? Done. This is your 184. Yes. Then we have small section duties of director 166. Okay. Yes, bhai sahab. Subsequently interest will rise. No. It just says that at the time when he was there, I have intention to buy the moon. Understand one thing. At the time when he casted his vote, that time he was not interested party. So law says that at that time he was not interested party. See, its intent is different and shareholders will appoint you is different. Understood? At the time when I was participating in that resolution, I was not interested party. Therefore, vote is valid. And now onwards, later on when you are appointed, after that you cannot participate further now. Because now that interest is arised. Earlier interest was not there. How we will prove that intention then? Correct. But then in that case there will be every day there were suits will be filed for everything. But there is no such rule. Rule says that if it is specifically given here, right? When do we go with the implied assumptions? When law is silent about this. Whatever question you are asking, for that law is not silent. It is expressed clearly that if the interest arises subsequently, then that director, whatever he has casted his vote is valid and later on he cannot participate. That is already given in law. Correct? Now, what you feel right, what I feel right, doesn't carry any value. It's not that simple, boss. See, firstly, he cannot further participate in that matter. Secondly, if he's still doing it, there are penalties, there are disqualifications, there are so many things are there, right? So, what 1 lakh? You have to leave your office 167. Contravention of 184. There are many things. So, we just think about the possibilities. So, think about the consequences also. Possibilities and consequences also. So, law has covered everything. Okay. It is not that simple. Come on, now we are moving to 166. That is duties of director. Come on, what is duties of director? Very simple. What are the duties of director? Come on, it is the duty of every director to act as per articles of company. You know, AOA are the rules and regulations of company. So any person who runs the company will obviously have to run the company as per the rules of company. It is a duty to act as per AOA of company. Second, it is his duty to act in the good faith of company. What is good faith of company? It is his duty to act as per the object of company, for the benefit of members, for the interest of company, interest of employees, interest of shareholders, interest of community, protection of environment, acting in good faith. Then he need to exercise his power with due care. Means he should take all his decisions with reasonable care. What does this mean? Why directors have to exercise that power with reasonable care? Because if you take decision under influence of someone, or if you don't take decision with reasonable care, one wrong decision will lead to loss of investors' money. So therefore you need to exercise his duties with reasonable care. Right? Then duty to avoid conflict of interest means it is the duty of director not to get involved in a situation which have direct or indirect interest that conflicts possibility with the interest against the interest of company. Okay, thank you Rugved. All the very best. Yes, chalo. Next, what is duty? Next duty is duty not to make any undue gain. Means it is the duty of director not to make secret profit. Then next is not to assign his office. You know this very well. Directors cannot assign his power to others. However, if you have studied section 179 powers of board, in that there is one point. Not one of the powers, but before the powers of list of power starts, there is introduction. The point is given. Board may delegate power to any of the director, officer, committee by passing board resolution in board meeting. But that is power delegated by board, not by the director. So director cannot assign his office to anyone. Understood? Board by passing board resolution can delegate powers under section 179. This is the duty of director. Okay, so these all are the duties. If any breach of duty, if director contravenes any of the provision of this section, it shall be punishable with fine of rupees 1 lakh to 5 lakhs. 1 lakh to 5 lakhs. Easy. So we're done with this section also, very simple. And last one is, you can see section 170, that is register of directors and KMP and their shareholding, right? Means, you know what, companies maintain a register, you know, as company maintains ROM, register of members. Similarly, company also maintains register of directors and KMP also at its registered office. Whenever a director or KMP is appointed in the company, their details are added in the register of directors and KMP. Whenever the director or KMP is removed, they leave, vacancy, again changes will be made in this register. So this register contains the details about such people, right? Very simple. Here you can see one example of case law. And members' right to inspect the registers, right? Very simple topic. Obviously the registers of directors and KMP shall be open for inspection during business hours. Members have right to take the content from the registers. Also they have right to take the copies of that registers on request, and company have to provide them the copies within 30 days free of cost. Okay, and this register is also open for inspection at every AGM. So members can inspect these records in AGM as well. Okay, if inspection is refused, so in that case what you can do, ROC may pass order on the company to supply the copies. So you can apply to ROC basically. Okay, simple. And this section 171 that is about inspection right, is not applicable on government company in which entire share capital is held by the government. Means the entire membership is the government only. Right? So this section is not applicable 171. And with this we are reaching to the specimen and your chapter is over. So we are done with the directors from your module, right? So yeah, exact on time. So I hope everything is clear. Okay. So in the next class we will start with debt instruments. Okay, everyone on screen. First we will be doing what? Deposits. In debt instruments we will be doing deposits. Okay, after deposits we will take some other chapter. Debenture part is very simple. Okay, and the question what is asked here is chapter 10. Chapter 10 what you want? Amalgamation. Okay, and 18 annual report. It's very simple beta. Chapter 10 let's see we'll do. Okay, fine. That is board composition chapter. Let's see. देखते हैं एज अ टाइम सबकी इच्छा पूरी करने की कोशिश कर सकता हूँ लेकिन इन द प्रीवियस वीडियोज दैट चैप्टर इज ऑलरेडी कवर्ड देर इज नो चेंज इन दैट यू कैन रेफर दैट ओके सो थैंक यू सो मच एवरीवन इफ यू हैव अंडरस्टूड एवरीथिंग जस्ट गिव अ लाइक थैंक यू सो मच बाय बाय हाँ बोल अभी बोला